Your Lordship, in the case of Peter Munya, the issue of inherent case is what I want to address using the ruling that was delivered by Justice Richard Mongo in petition E014. Your Lordship, and this is what the learned judge found upon perusing the documents, that on my motion, I had perused the file and considered that the matters being considered on impeachment of the Deputy President of the Republic of Kenya are novel. That is the first issue. The other issue by the judge was that there exists no statutory or subsidiary legislative framework for impeachment of the Deputy President. The learned judge also said that there exists no statutory framework for public hearings and public participation in respect of impeachment of a Deputy President under Article 145. The learned judge also identified another issue, that there have been several bills on public participation and also on the question of impeachment in Parliament, but such bills have never been passed. And then finally, the judge says that the law on these questions has not been settled. It is our submission, therefore, Your Lordship, that based on these issues that have been framed by the judge, this is a proper case for issuance of conservatory orders so as to preserve the substratum of the petitions. Your Lordship, the last issue I want to address is the issue of public participation. Mr. Omari has pointed out the issues which we have in our petitions, and also finally the issue of the Senate. Your Lordship, in our petition, we have questioned the legality of the Senate having taken the position that it was open for them to use the plenary route as opposed to the committee. On that basis, therefore, Your Lordship, these are serious issues that warrants issuance of a conservatory order. Your Lordship, my colleague will conclude. I thank you.
Thank you.
Yeah, thank you. Thank you very much. Very briefly, my Lord. And I'll just be making some remarks on the two applications for setting aside of the conservatory orders, starting with petition number 565. And looking at the prayers that are sought in that application, my Lord, that application is moot. I say so because the substantive prayer number 2, was that pending the inter partes hearing of this application for setting aside, that the orders issued by Justice Chacha Mwita be varied or set aside. My Lord, we already passed that stage, and therefore that prayer is not available. Then prayer number 3, that in the alternative, this Honorable Court be pleased to set aside, vary or discharge the ex parte orders issued on 18th October 2024. My Lord, those orders lapsed on Friday, that is the 25th of October 2024. So just to make the court's work easy, there will be no need to consider that application. Having said that, and in view of your previous directions, that this application will be treated as a response to the application for conservatory orders, I would just like to make 2 or 3 remarks with regard to the content of that application, my Lord. And I would just like to mention that paragraph 7 of the supporting affidavit sworn by the Solicitor General. Actually, it is in the ground, but then it is reflected in ground number 7, my Lord. It says, Article 1 of the Constitution provides that the sovereign power belongs to the people, and that where there is a conflict between public interest and private interests, the scales of justice to tilt in favor of the public interest. To that, my remark is, the question that is before you is not about a private right. It is a more elevated constitutional question of impeachment of a president or a deputy president. Again, paragraph 8 states that the Constitution does not envisage a vacuum in the office of the deputy president, and as such, it is in the interest of justice that interim orders be stayed, varied, or set aside. My Lord, Article 149 and Article 150 make very clear provisions on the vacancy of the office of the deputy president and how that is treated, even about the vacancy in the office of the president and how all that is dealt with. The Constitution is self-sufficient with regard to vacancy in the executive offices. Just 1 minute. I'd like to make a remark, still to make the court's work easy, in a petition number 15. And my Lord, again, that application is moot. I had to check the one that is on CTS just to be double sure. And the substantive prayers that are sought are prayer number 3. It was an interim order pending inter partes hearing of that application. My Lord, again, we are beyond that stage. We are already at the inter partes stage of the hearing. So the remaining prayer is prayer number 4. And allow me to read it verbatim. That this court be pleased to set aside, review, or otherwise vary grant the ex parte orders issued on 18th October 2024 by Honorable Justice Mwongo Richard Mururu in Kerugoya Constitutional Petition number 15, pending the hearing and determination of the appeal. My Lord, what the National Assembly clearly did not disclose is that after these orders were served on them, they went and filed an appeal. And then filed this application to stay the conservatory order or set it aside pending the determination of the appeal. That has not been disclosed to the parties. It has not been disclosed to the court. So you have no prayer for setting aside of the conservatory order pending the hearing of the petition or pending the hearing of the application for conservatory orders. So again, that application is moot. Turning to the content of that application, in as far as it is a response to the application for conservatory order, firstly, the decision or the subject of the petition before that court was the proceedings before the Senate. Then again, the National Assembly was not necessarily the aggrieved party, but again, they cried louder than the bereaved. Again, if you look at paragraph 6 of the supporting affidavit, shown by paragraph 6. The applicant is aggrieved by the order of 18th October 2024 and seeks for the order to be temporarily set aside. Not entirely, my Lord. Temporarily set it aside, pending the hearing of the appeal. My Lord, that is not an appropriate ground because no appeal has been placed before you. At paragraph 7, which is a serious misconception. Yes, my Lord.
You had very few minutes. I think you have exhausted them.
Judge, I beg only two. Only two, Judge. Thank you. at paragraph 7, you realize another basis of making this application, which is a very serious misconception. And it says, a presidential system of government works based on the doctrine of collective responsibility. This is a constitutional democracy that we have. The doctrine requires members of the cabinet to work in unison for the sovereign and promote the collective policy agenda. In pure presidential systems, which is not ours, the president retains the discretion to dismiss a member of cabinet who falls short of the expectation. Well, one of the reasons why we have the current constitution is to prevent this very mischief. So we can clearly now see the underwriter of all this impeachment process. It is the president who decided a member of the cabinet should not be here. So this is a process that is...
Objection, that is evidence from the bar.
I'm just picking a paragraph in the supporting affidavit.
Mr. Watuta,
Yes,
please conclude your remarks.
Very well. Thank you. Yeah, and even more worrying is paragraph 8. Additionally, reinstatement is inconceivable where the member of the cabinet has lost confidence of the sovereign and parliament. My Lord, Article 150 sets the ground for impeachment of a deputy president. Lack of confidence is not one of them. Lack of confidence by parliament in the deputy president is not one of the grounds. So we can clearly see the reason why we have the impeachment process. Who is the sovereign? The people. When did the people say we have lost confidence in the deputy president? So all these other grounds, as we will demonstrate at the hearing of the petition, is that it's just a facade, it's just a face to hide the real intention of members of parliament saying we have lost confidence in this particular person. I do not want to go to paragraph 9, but again, those are matters that we'll deal with at the petition stage. But all in all, my Lord, you only have two applications to consider, the ones for conservatory orders. The one for setting aside the conservatory orders, my Lord, I've made your work easier. Most obliged. Thank you very much.
Thank you.
May it please the court. My name is Dr. Eboso. I'm from Vihiga, and I'd like to...
Dr. Eboso, you'll address us for only 5 minutes, please.
Lord, I will do my best, but I promise I will not repeat anything that has been said. My Lord, I'll go straight to the points. One, what is on trial, or what is at stake in the setup of an interim conservatory order? My Lord, I'd like to inform the court that what is on trial is a Bill of Rights. Article 38 of the Constitution provides that a person has a right to vie and be elected for office, and if elected, has a right to hold that office. My Lord, that is one of the things that is on trial, but I will ignore that for now. What is at stake, because a conservatory order is supposed to preserve the substratum, is a right to a fair trial. My Lord, the components of a fair trial include the tribunal that is independent. It includes the process and the outcome. My Lord, the outcome includes the remedies that are available by law to the individuals before the court. One of the remedies, the material remedies that the parties before this court are seeking, is reinstatement of Deputy President Rigathi Gachagua to office. Therefore, and I will demonstrate when I talk about the Wajir case at the end, that once a new person assumes that office, that remedy is completely taken off the table. And that means these conservatory orders are actually at the heart of a fair trial. And a fair trial is among the rights under our constitutions that cannot be limited. It is not that a fair trial is absolutely not limitable, but that the state through its action or any person through their deliberate action cannot limit the right to a fair trial. Why do I say this? During a trial, the witnesses may die naturally. COVID may happen and cases are delayed naturally. That is extrinsic and it may affect a fair trial. But the court must never do anything deliberately that would impede a fair trial or that would be imputed as limiting the right to a fair trial. So, my lord, by lifting this conservatory order, you will be actually limiting the rights of the petitioners to a fair trial by taking away a very material remedy to the remedies that are available to them. I'd like to talk about what is the place of the Bill of Rights under our Constitution and the concept of public interest, because it has come up very much. Now, our Bill of Rights under our Constitution is very fundamental. The Bill of Rights, the chapter on the Bill of Rights, is the only chapter under our Constitution that has its own doctrine of interpretation. And the Bill of Rights is enjoyed individually as per Article 19, is by individuals. It is actually antithetical to the concept of human rights and individual human rights to say that the Bill of Rights will be enjoyed at the behest of a public interest. They are actually specified there expressly, especially to be enjoyed in spite of the public interest. So I feel like the argument that the public interest should be balanced against the Bill of Rights is antithetical to the very concept of the Bill of Rights. The limitations of the Bill of Rights is captured in Article 24. And I would have read the entire article for us to see. But the provisions that it provides is that the Bill of Rights will not be limited except by law. And then only in a manner that is reasonable and justifiable. My lord, the public interest that has been propounded by at least the response by the Attorney General, or the application that by the Attorney General, did not disclose the legal basis of that public interest. In fact, it was just general. And it brings me to the question. It reminds me, in 1945, the Supreme Court of the United States was faced with a case about the Anti-Obscenities Act or Anti-Pornography Act. And Justice Stewart, unable to define what pornography is, in his concurring opinion, wrote, "You will know it when you see it." My lord, that is the kind of public interest that the Attorney General is asking us to use to balance against the Bill of Rights. A public interest that we cannot really tell what it is. My lord, the public interest that should be able to limit the Bill of Rights must be founded in law. There must be a legal basis for which you're saying this is a public interest. Whatever the Attorney General has propounded, in fact, has not even specified. It must not be vague. It must be very specific so that we can assess its reasonability and whether it can actually be justiciable or it's justified within a democratic society. My lord, I saw in the response by the National Assembly, the public interest has been a bit defined and has been stated as the fact that we do not have an IEBC. My lord, that is not a legal question. The other issue was that we cannot stay without a deputy president. My lord, as had been propounded earlier, kindly allow me 2 minutes. As has been propounded earlier, my lord, the Constitution allows us not to have a deputy president for at least 60 days, in fact, 74 days. So we don't yet have a legal crisis as we speak. We may have a political crisis, but it's not a legal crisis. The absence of an IEBC is a political crisis that cannot be brought before the High Court, a court of human rights, as for that to be balanced against human rights. My lord, the political arms of government are the ones best placed to deal with a political crisis. And tomorrow they can appoint an IEBC if really there's a political crisis. Finally, my lord, I would like to bring attention to 3 cases by the Supreme Court. The Munya case, Martha Karua case, and Speaker Mate case, because they kind of explained how conservatory orders ought to be interpreted. And my lord, what I read from those cases is that a court order through a conservatory order cannot overthrow the constitutional values and constitutional imperatives. A conservatory order by the court fetters discretion, constitutional or statutory discretion, never constitutional obligation. And so, my lord, in the context of this conservatory order, the conservatory order cannot be interpreted in a manner as to freeze time. because one of the things that is considered by all parties in this case is that an impeachment did happen, and it's presumed to have happened lawfully until this court finds that it did not happen lawfully. By that, the Constitution is very express that the office will fall vacant. And so that one, however much a court attempts, it cannot constrain an edict of an imperative of the Constitution. So the office is vacant as we speak. However, time started running, and the president had 14 days, a discretion of 14 days. The court order can fetter that discretion, and where it seems to the court that the discretion was abused and rushed in order so that you can avoid the rule of law and whatnot, the court can make the conservatory order to be deemed as if the action was done, as if that abuse was not there. So that the president still had the 14 days, and so the time is counting. Parliament will still have 60 days. Now, at the end of the 74th day, this court's conservatory order, however much it tries, it cannot extend beyond that. Finally, my lord, I want to talk about the Wajir case because nobody has talked about it, and it was part of the Attorney General's application and response. The Wajir case relates to a governor who was impeached. The deputy governor assumed office and then even nominated a new deputy governor, and then later on, the High Court found the impeachment to have been unlawful and reinstated the governor back to office. My lord, there is a distinction, both a constitutional distinction and even a procedural distinction in the two cases. In the Wajir case, the court had issued a conservatory order against the assumption of office, which was defied. But aside from that, because that still is arguable as to whether a conservatory order can do that, there is the question of part of the rule of law and a fair trial is the enforcement, the enforceability of a court order. Now, a court order may be enforced against the deputy governor or the governor of a county. But as per our constitution and as per the holding of BBI in the BBI case, the presidency is absolutely immune. No amount of court order will be issued that will be able to be enforced against it. Because who will enforce the court order declaring the office of president vacant? My lord, it's the political arms of government that can deal with that. And that might be one of the issues that are political questions that the court cannot really address. So, my lord, as far as the office of the deputy president is concerned, such an order cannot come from this court. We cannot allow the conservatory order to be lifted, and then we imagine that we will be able to enforce an order removing Professor Kindiki from office. My lord, thank you very much. I'd like to ask my co-petitioner, I think petitioner number 12.
I wish to make an application under Article 57 of the Constitution. All the members of the file. The owner is now 2:30. Some of us have to eat at 7 intervals. Also, I'm mindful of the court. You have been sitting all the time. You must be now very tired. It has adjourned extremely quickly.
I think my lord, those who are angry can leave. Strong ones.
My lord, I would like to support the request, very polite request from Dr. Haminwa. Dr. Haminwa is the #1 longest serving member at the bar. And yours truly is #2. So my lord, breaking for an hour or so is a very appropriate thing to do. And I ask the court.
We want to break by some order. Yes. We want to complete the applicant's case. Then we can break.
Okay. We will persevere.
You are the last one.
Yes, my lord.
How much time do you want?
I need 5 minutes, but I would appreciate it if you don't knock because I have dyslexia. So it will make me start rapping instead of delivering my submissions.
5 minutes, please.
Yes, my lord.
Your name?
My name is Wanjiro Mwangi. I am the 12th petitioner in consolidated file E65 of 2024. And together with the 11th co-petitioner, Dr. Eboso, we asked to be enjoined as interested parties in this matter. My lord, unlike most people in this room, I want to disclose that I have a learning disability or ability called dyslexia, so I ask for time not to rush me so I can articulate myself properly. My lords and my lady, I would like to ask this court to deem myself and Dr. Iboso being properly on record, for the sole reason that in other courtrooms we have made submissions and been told that we are not properly on record, and would like our submissions to remain on the record. My lords and my lady, I only have 5 questions today that I want to task to the judiciary and to the members of and to the public and to everybody else. Question number 1, the judiciary on trial. My lords and my lady, the only questions you're on trial for in the eyes of the public is a simple one. Is the judiciary truly impervious to the reach of the corrupt and the political class, locally and internationally? If the answer is yes, the Bill of Rights must be respected and upheld. For this, I rely on Article 159(2), justice shall be done to all, irrespective of status. Read together with Article 27(2), which states, equality includes the full and equal enjoyment of all rights and fundamental freedoms. Question number 2, the Constitution on trial. My lords and my lady, the second question the public will be asking is, when our Constitution is on trial, because it is no doubt on trial, will the judiciary bend to the insurmountable political pressure, or will jurisprudence, the Constitution, and the rule of law prevail in such adversity? If the answer is yes, then the conservative orders must be stayed. For this, I rely on Article 27. Every person is equal before the law and has the right to equal protection and equal benefits of the law. Question number 3, the laws on trial. My lords and my lady, the third question that is important to the public is that once a court clearly states that a right is absolute, as this court did on the 23rd of October 2024, then the public will be interested to see and know if the court will uphold its own directions. If the answer is yes, then this court must respect and uphold its own directives and guarantee all the petitioners, especially those who prayed for conservative or injunctive orders whose applications have not been heard and determined, including us laymen, the right to a fair trial as specified in Article 50, which reads, every person has a right to have any dispute that can be resolved by the application of a law decided in a fair and public hearing before a court. Read together with Article 27(3), women and men have the right to equal treatment, including the rights to equal opportunities in political, economic, and cultural spheres. Question number 4, immunity of the office of the president is on trial. The inadvertent question we as a society have to ask ourselves is a moral one. Does the court have any real authority to successfully reverse the impeachment and reinstate Rigathi Gachagua? Based on the truth we know, the truths we have been shown, and the truths we are constantly reminded of by the political pandemic we have been suffering, what confidence does the public have that if the conservation orders are lifted, the court will have any real authority to successfully reverse those orders? Then, under the same assumption, the ascension of Professor Kindiki will succeed after that in a manner of what we expect to be ours, despite the numerous legal ambiguous queries about gazette notices in the middle of the night and a lack of IBC commissioners to vet or validate the public participation in that manner. The answer is no. The court will be unenforceable, will be unable to enforce on the office of the president as enshrined in the Constitution and affirmed by the Supreme Court. The court does not have jurisdiction to force Kindiki, if he's sworn in, to recuse him, to impeach himself. That is the real conundrum in a nutshell, and is as simple as the deputy president assumes office, and if the president is unwell, does the judiciary in fact find the impeachment and end if the, sorry, let me just say it again, please. The real conundrum in a nutshell is as simple as this. If the deputy president assumes office, and then the president is unwell, and the judiciary does in fact find the impeachment process was flawed from the National Assembly due to violations of the Constitution, what then? Will the acting president impeach himself as a deputy president? Can he even, is it even possible, and who would enforce those orders? The conservation orders cannot be lifted if they will be rendered a nullity, null and void. For this, I submit Article 27. The state shall not discriminate directly or indirectly against any person on any ground, including race, sex, pregnancy, marital status, health status, ethnic or social origin, color, age, disability, region, conscience, belief, culture, dress, language, or birth. Question number 5, and my final question today, is our system is on trial. My lords and my lady, on this final note of mine, I humbly stand before you as a layperson with arguably what I hope to be some of the best legal minds in this country. As our nation is once again at the precipice of a revolution, as the spirit of our nation is reawakening, I submit to you one of the most progressive documents in the modern world, our Constitution, a document which guarantees even terrorists due process, whose preamble starts with "We, the people of Kenya," and ends with "Adopt, enact, and give this Constitution to ourselves and to future generations." It is time to take our place. It is time for the Constitution to prevail. It is time to no longer allow political urgency to override judicial processes. Our country will still be intact in 30 days, and it will still be intact in 60 days without a deputy president. Our Constitution went so far to envision not only the vacancy of the deputy president, it planned for the eventuality of both the president's office and the deputy's office being vacant. Kenya will be fine. We, the people, will be fine. Let the natural cause of justice prevail. It is what we envisioned, and it is what we envisioned for an independent judiciary. Thank you, my lords and my lady. I submit the floor.
Thank you.
It is now 2:30. We will adjourn. I want the assurance that we are coming back for the respondent's case.
Yes. Your Lordship, that's not correct. My name is Moraro Moke, Counsel. I'm the 43rd petitioner. And I understand from your direction on Friday that you would hear all applications for conservatory orders. I would like to be guided on that issue.
Which one is your application?
My application is to be found in the petition E027 of 2024.
My Lord,
File in
that petition
Eldoret.
is not consolidated with this.
Hello?
It is consolidated, Your Lordship. Mr. Wanyama, just hold your horses. The petition was consolidated by an order transmitted to me on Friday by the Deputy Registrar, indicating that the two additional petitions had been consolidated. Can you kindly confirm that?
I informed all parties that we continue to receive petitions in this matter. We received petitions as late as yesterday, and by the very nature of those petitions, they seek invariably the same orders and the same prayers. But when a petition comes after we have given directions on other petitions, certainly you would not expect us to go back on the petitions which are not before the court.
Your Lordship, if you allow me to read the order that I was given, perhaps it can shed more light.
Yes.
The order said that petition had been consolidated and I'm required to follow the directions issued on Friday in the in the other petitions. That's what the order states.
My Lord, unless I'm mistaken, we were here to hear applications, two applications in petition, one in petition 522, one in petition 565. Equally, we were here to hear two applications from this side that my Lord directed will be treated as the responses to the applications on the other side. If my colleague's file has been consolidated with these files, it does not necessarily follow that his application also had been scheduled for hearing today. And lastly, my Lord, while I'm on my feet, I know we started by giving directions and the court being fair and allowing the parties to drag on and on, but we are concerned on this side that unless the court is able to fix a stop at some point, the other side is committed to proceeding on and on, as I said, until donkeys grow horns. And
Mr. Omoke, how much time do you want to submit on your application?
Your Lordship, I always speak very briefly. I will take only 5 minutes.
Proceed.
And I'll do it right away.
We will be disadvantaged slightly with Mr. Omoke's application because he has filed written submissions that he only served on us late last night that we have not responded to.
Your Lordship, the submissions I filed, they raise the same cases that we all know about. That's the case of Gachagua, which I believe we are sufficiently aware of. And Your Lordship, as you consult, I would like to add that even
Please don't disturb us when we consult.
That's okay.
My Lord, to end the agony, we have consulted and we concede to submissions in 5 minutes on points of law.
These are the directions we are giving. Mr. Omoke, your petition, we gave directions that it has been consolidated with the petitions before the court. But the fact of consolidation does not mean that your application will be heard. However, because your application raises the same issues as the application before the court, we will give you 5 minutes to canvass that application. And after that, we will adjourn to come back to consider the respondents' responses. Thank you.
Thank you, Your Lordship. My application.
I have a problem. I represent, I'm holding a brief from Madam Prime Minister Ashford Muluki. He represents a political party, I represent a political party by the name of Maendeleo Democratic Party. And we filed an application, and our understanding was that Mr. Mukoko was to be heard today. I wonder if you could take that into account also. Maendeleo Democratic Party.
Which petition?
Which petition is that?
It was not here a petition, it was a motion application.
In which matter? In which matter?
It was to be enjoined in the
Is it cohort 2 or cohort 1?
E565 2024.
Maendeleo?
Maendeleo Democratic Party.
My Lord, that's not a party in both cohort 1 and cohort 2.
Maendeleo Democratic Party is not a party in any of the two cohorts. It's not a party in any of the two cohorts.
I see. That's interesting.
Okay, Mr. Omoke.
May I say something again?
But Dr. Kamina, you know you appear in cohort 1 in your own right.
Yes.
Remember that. So if you want to submit in your own right, we will allow you. But for the person you are holding whose brief you don't appear, to see where he
I
is.
think Ashford himself, I don't know.
Just look for him so that he can prosecute his case. That in the meantime, let's have Mr. Omoke.
One final word, my lord. My lord, I like being human, and I like taking care of the interests of the judges when they are sitting. You are human. Why don't we adjourn tomorrow?
Dr. Kaminwa, please.
Being human.
It's okay. We are very human.
All that I'm saying, can we start tomorrow?
Let's have Mr.
My lord, I think the cat is coming now out of the bag.
Mr. Omoke, you have 5 minutes.
Cut now.
All right, Your Lordship, if I may proceed. I would like to indicate that I support the application of the first petitioner, and I also submit in support of my own application, which is dated 9th of October, 2024. I wish to rely on the affidavit sworn on the same day. My submissions filed yesterday, dated 27th of October, and the list and bundle of authorities. In summary, I would like to state my, Your Lordship and my lady, Your Lordship, Presiding Judge, Your Lordship.
What's the date of your submissions?
27th of October. I confirm that I personally attended the public participation at Kiambu Social Hall on 4th of October. And that, from what I observed on that day, I was convinced that I had a responsibility to come before you under Article 3.1 to defend and protect this constitution. That there are serious violations which this court must consider, and in line with the Gachagua Munya case, there's public interest at stake. Gachagua Munya. There is an inherent, there's a case that you need to consider here, where we must look at all those issues on public participation. Was there proper public participation, not just on the day when the parliament was conducting it on 4th of October, but even prior to that, under Article 10, I would call upon this court to issue the conservatory orders so that you can have an opportunity to re-examine Article 10, which for a long time has been seen as though it is something that is aspirational. And I would like to urge the court to consider this to be something that is binding on all persons and all state organs. So such that for the move of the motion in the National Assembly, at the time he was seeking to bring that motion before the National Assembly, he actually was bound by Article 10 to observe all the values contained therein, including public participation, go around the country and speak to the people. And I'm here to tell you, my lords and my lady, that the people of this country are angry from what I observed on that day, on 4th of October, and they are sick and tired of how the Constitution is being violated.
Well, as counsel is testifying, maybe he can take to the dock so that we can all have an opportunity to cross-examine him.
I saw
testimony that he is.
Yes, in response to Professor's objection, I am a party personally, and I saw an affidavit, and I've made all those averments therein. And if I'm required to be examined, I'm very much happy to do that, if you require that. So perhaps Prof can confirm, and I'll take the doc very happily. All right, so I'll carry on. He has agreed that you wouldn't like to examine me, so I'll continue with my presentation. Actually, at that very same public participation, I did meet some of the people from his famous home, Ndumberi, otherwise known as Danbury, and they were very, very unhappy with the way the process was being conducted. And that's why I've come here, not just to speak for myself, but also for all of these people. I would like to tell you, Your Lordship and my lady, I'll close my presentation here because I know that we have an opportunity to examine these issues at a later time.
Thank you. These are the directions we're giving. It is now 20 to 3. Is it? Yes. We can take a 45 minutes break. We come back at 4:30. 4:30.
I had it to say
3:30.
that
3:30. It is now 20 minutes to 3.
That's correct.
So we can come back at 3:30.
Only one thing, Your Lordship, that we still have interested party who might want to support the application. You indicated that you'll be coming for the respondent's case.
There's no problem. You are coming back at 3:30.
Excuse me. I'm looking for the quorum for E565 of 24. Kindly, if you have the quorum for E565, we need it to make copies. You're happy. Fantastic.
Mtazamaji wangu, bila shaka hayo yamekuwa ni matukio ya sheria ambayo umekuwa ukifuatilia katika mahakama kuu ya Milimani hii leo, ikiwa upande wa naibu wa rais Rigathi Gachagua umeweza kupata nafasi ya kutoa malalamishi yao na maombi yao mbele ya mahakama hiyo ambayo inasimamiliwa na jopo la majaji Anthony Mrima, Eric Ogolla na Daktari Freda Mugambi. Ni kwamba kutoka muda wa saa 5:30 hivi hadi hivi sasa saa 8:43 upande wa Rigathi Gachagua umepata nafasi ya kuweza kujitetea vilivyo mbele ya mahakama na kuomba kesi ambayo itaendelea muda hapo baadaye, kwamba mahakama isiweze kuondoa vizingiti vya kisheria ambavyo vitaweza kuidhinisha naibu wa rais mteule Kithure Kindiki kuweza kuapishwa. Walipofika mawakili wa Rigathi Gachagua, mtazamaji wangu, tuliona wa kwanza Paul Mwite akichukua usukani na kuweza kusema mbele ya mahakama. Katika sasa niseme na wageni wangu studio.
Tunajipenyeza kwenye vitongoji, mijini na jijini kukuletea matokeo ya matukio kila yanavyoibuka. Mbashara. Tazama Sound Candy Talk kwa habari sahihi. Kwenye kilele cha Mount Kenya hadi mabonde ya Keio Valley, hii ni Sound Candy Talk. Tunajipenyeza kwenye vitongoji, mijini na jijini kukuletea matokeo ya matukio kila yanavyoibuka.
I think his security was beefed up since he was nominated. When you say the President William Ruto perhaps travels and there's that vacuum, and we have an elected deputy president and a nominated deputy president, where does that leave the country?
You see, the court is looking at the process which was followed at the Senate and even at the National Assembly. And therefore, if today we were to lift these conservatory orders, what then will happen is the case that has been filed by the lawyers for Deputy President Gachagua would end up being an academic exercise because we'd already have a deputy president. And when we have a deputy president, it basically means the impeached Honorable Gachagua will then have a very hard time after going through the court process, coming back, and now we removing the Professor Kindiki from the office. And so that's why we are saying it's important to conserve, or rather we are saying it's important to conserve to hold on to have the conservatory orders and not to swear in Professor Kindiki, because then the questions which have been raised by the petitioners will not have a proper chance to be heard.
All right.
And there are actual issues, there are issues which have happened, we saw them happening. And so it's important to actually allow all the parties to be heard, because the other interpretation that they have raised in court was, we have the president, and even as Kenyans, we have 74 days to have a deputy president. So there's no hurry in this process. We should allow the process to be finalized, the court process to be finalized, and then we can then say that the conservatory orders can be lifted.
So are you trying to say that perhaps if the judges are to, go in favor of the state and lift the conservatory orders and swear in Abraham Kithure Kindiki, the case of deputy president, that's the end of it? That's the end of the road for him?
Not really, because we have seen before where the court has reinstated a governor. And so in this case, if they were to proceed and lift the conservatory orders, then we'll still continue with the hearing of the main case. Remember today, what we had in court is just an application for conservatory orders. We still have petitions which have been filed, over 30 applications which have been filed on the issue to do with the process which was followed by the Senate, by the National Assembly. And so we will have a chance to still proceed, only that the law is that if there's a prima facie or there's a case to be had, if there's any damage to be caused, and I saw a lawyer by the name of Shadrach Wambui argue that there is a cost implication if we proceed with the swearing in of Professor Kindiki. What will happen is we can still proceed, but we're going to lose so much as a country. So that's the
maybe a Kenyan will want to know, if at all Kindiki is sworn in as deputy president, the case, against the impeachment of deputy president Gachagua goes on, and he wins this case, what will happen at that time? Would you come and remove Kindiki as the deputy president? Will you have two deputy presidents?
We're saying this is a historic moment in Kenya. This is the very first time that the provisions of our Constitution 2010 are being challenged. Articles 149 are being challenged on how to remove a deputy president. And therefore, it would be very interesting to see what would happen if we had Professor Kindiki sworn in, and then a deputy president wins the case in court. It would be quite interesting to watch the scenario, because I believe if orders were to be issued by the court and they were to be served upon a deputy president who is sitting, as in this case being Kindiki, then it will be a very interesting scenario to see if there will be a reversal process, because under the Constitution, we have only very few grounds where we can remove a sitting deputy president. And one of those scenarios is through impeachment, through sickness, through resignation. So we do not foresee where a court order is served to reverse the process by which someone is already sitting in that seat.
One of the key issues that the petitioners were raising this morning actually was the hurriedness of the impeachment motion of then Deputy President Rigathi Gachagua, because you wake up in the morning, he's impeached. Next minute, MPs have, the State House has sent in a name for the nomination. Next thing, Parliament has approved the nomination of Kithure Kindiki. Where does that leave Kindiki in this particular case? Because when you look at the constitutionality, the IEBC is required to verify the nomination of this candidate. The Kindiki should also have resigned 3 months prior to that. So where does that actually leave all these Kithure Kindiki's nomination as the deputy president?
This is where the court says that you should not discuss matters which are in court when they are ongoing, because these are some of the issues which are being raised.
Yes.
What does this leave us with?
Yes.
We are looking at the process. Was it properly done? Did we have a proper constituted IEBC? Did we have at the office of EACC, which is run by Bishop Oginde, at work in the middle of the night? These are some of the questions which have come up in this argument. And I believe the judges are listening and they are going to make a well-reasoned out decision
But
when it comes to
the
that decision.
Constitution,
Yes.
right? According to the Constitution, IEBC has to be in place so that they can verify this particular nominee, that is one. Two, public participation, in that Kenyans are given a leeway to give their views on the nominee of a deputy president. Those are just some of the concerns in terms of...
There are two sides of this conversation, because when you plainly read the provisions of Article 144, 145, 148, 149 of the Constitution on impeachment of a deputy president, it just says that the president, upon receiving the name from the Speaker of the Senate, shall proceed to nominate and send that name of the nominee to Parliament. It does not give any other provisions. That's one argument that is being made by one side. The other side comes in and says, no. This is an electorate process where in a normal election process, we have to also look at the Elections Act. We have to look at the procedure of nominating a candidate for that office. And through that process, when we go into an election season, they have to present, for example, their academic documents. They have to go to the DCI office and EACC offices and get those certificates to show that they have not committed any crime. They are proper for that office. That's the other side that is arguing that. And so we ask, what is the actual position? And this decision is going to help us very much to make it clear in future, because this is the very first time we are having this impeachment process of a deputy president. This is going to help us in future because it will help us have a proper guideline. And someone has even argued today that we do not have some rules and regulations on the impeachment process. We are only reading plainly the Constitution. And what happens with any constitutional provision, it has to be given the legs and the feet and the ears and the mouth through as a legislation, like when we have an act of parliament. So we don't have an act of parliament that supports the impeachment process. So this is a momentous moment. This is a historic moment in Kenya because we await to see what the three judges are going to do. Are they going to give a direction? Are they going to help us avoid such a scenario in future?
That makes me wonder, because when we go back to the impeachment of Meru governor, that is Kawera Mwangaza, after she was successfully impeached by the Senate, the next day they rushed to court. She got a conservatory order and she was back to her office. Now we also have a deputy president here. I don't know whether it's similar, because successfully impeached, goes to court, gets a conservatory order, but cannot access his office. How different are these two impeachments, perhaps?
So they are similar. They are similar processes. Only issue is that one has a lot more attention and has more interest because it's for the national office. This is the office of the Deputy President of the Republic of Kenya, while the other was for the county government, or rather the governor of the county. And therefore, when we have these impeachment processes, it's both legal and political. So in a political process, there are a lot of factors to be involved. There's a lot of, for example, political influence that goes on. There's a lot of, probably, you even saw in the Senate, the evidence that was being produced wasn't as heavy, for lack of a better word, as it will be in a court process.
Yeah.
Because it is a political process. So you did not have to prove all these 8 or 7 allegations that were being made, or 11 allegations that were being made, word for word, and by producing that evidence. All you needed to do was allege and allege.
Yeah.
But when it comes to now the finalization and getting a conservatory order, what is coming into play is you have a conservatory order, which makes Honorable Rigathi Gachagua still the deputy president of this country, because the status quo has been retained.
So at the moment, do we have 2 deputy presidents?
An opinion has been given that we have 2 deputy presidents, but when you look keenly at the interpretation of the constitution, you cannot have a vacancy in the office of a deputy president. And with the court order, the conservatory order being in place, it has already maintained the status quo,
yeah.
of the person who already took the oath of office. Currently, Professor Kithure Kindiki has not taken the oath of office, and therefore he's just a nominee. He is not the deputy president of the Republic of Kenya. And so we, on the other hand, we have an impeachment process which has been challenged in court, and therefore, pending the hearing of this impeachment process, we would still say that he is an impeached deputy president, but he still remains in office, because you cannot leave a gap.
Okay, but one will wonder, why is Gachagua going all this way? You know, why don't you just let it go? Because at the end of the day, someone may wonder, you have a relationship that seems imparable with the president. So when perhaps you survive, perhaps Rigathi Gachagua survives, how is he going to work with the president? Perhaps people are wondering, why go all this way? Why not let it go?
Our constitution gives power to the president and the deputy president. The election process allows each Kenyan to choose the leader. I would believe that Deputy President Gachagua would actually is entitled to whatever he is going for, and even for the fight, because 1, he was elected by the Kenyans. 2, he feels that a proper process was not didn't go through the Senate and the National Assembly. And therefore, the allegations made against the person. For example, if today people out there went and said untrue things about you as a person, and you knew deep down these things are not true, I believe you would still stand on your feet and say that these things are untrue about you as a person. And so I believe him as a person, as an elected leader, he owes, for example, what he says, the Murima people, an obligation to continue sitting in that position and being their leader. So that's why he may be fighting for it. But also understanding that as a Kenyan, under the provisions of Article 48, the right to be heard, the right to fair trial, you can challenge any decisions being made against you. And so he's standing on that. He has constitutional rights to fight and claim that he needed a fair trial. He needed to be heard. He was sick. Why is he not being given a chance to be heard? So until such a thing happens to such a person, then I believe he's in his right mind to fight for his position and to fight and stay still in that position, even if his relationship with his boss may not be working. Yeah.
So in short, you're trying to tell us that should he be reinstated, it has to work between him and President William Ruto. There's no two way about it. But of course, at the same time, there's so many questions in regards to what is there for him to lose. Because remember, if he is successfully impeached, he's not going to vie for any elective position going forward for about 10 years, right? And is there any way he can try and battle that out in court, or his just case is it's either you're impeached or you save yourself from being impeached?
Yes, there are cases which have come to court. One of them being the Sonko case, the other one being the Kiambu governor case, former Kiambu governor Waititu case, where they were declared unfit for office. And so, if he does not fight this in court, and I know he's going through this whole process to verify himself, to find that, to make sure that the courts declare that the process done by the Senate and the National Assembly was not proper and they did not follow the law, then he's fighting to make sure that he's not declared fit to not run for any other office in this country. So that's why he may be fighting in court today. Yeah.
So why wouldn't he have resigned earlier? Because now, for him now, it's either you save yourself or you save yourself. There is no two way about it. Because if you're not saved, you're going home.
Well, I think in his right mind, he knew that he's elected by the Kenyan people.
Yes.
Number two, whatever allegations were being made, probably they were untrue to him, and there's no way he was going to resign and leave that office. And so he has a chance. That's what probably he feels, to go and fight it out. I believe any person who watched the proceedings and watched even the cross-examination by Advocate Elisha Ongoya can tell you that there was no proper case that was put in the Senate. For example, even beyond that, if we were to say that there was a proper case, was he given a chance to be heard? And that's the right thing to do. Just go out there and fight for yourself.
So perhaps you can enlighten us on what really the law says about or here trial where he was supposed to be given that right to actually come and defend himself. And for him, since he left the hospital, he says that he was denied that right because he just felt sick. Anyone can get sick. So when it comes to the courts, when it comes to the law, how does that favor Gachagua?
Well, there is a provision under the law on the Bill of Rights, which is, we call it audi alteram, or rather, that's a Latin word, but the actual word is hear the other party, which is a Bill of Rights. Anywhere under the law, if you are going to enjoy your rights as a human being, you need to be heard.
Yes.
And so he's claiming that. And so from the Bill of Rights, he deserved, even though he was unwell, he deserved to maybe given a chance. And they had requested, because it was on a Friday, they had requested, can they resume back? And this was done by Senior Counsel Muite. Can they be allowed a chance to come back on a Tuesday? Because Monday was a public holiday. And so that one, the members of the Senate acclaimed.
They're rushing against time.
They acclaimed and said no. But what time? Because when you look at the interpretation of the Constitution, when the matter is referred to the Senate had a chance to either appoint a committee of 11 members, and after, if they were to go that direction, they needed to give a decision within those 14 days. But on the other hand, if they do not go with that committee, the Constitution provides that they have another 70 days to finalize this process. And so there was no hurry, there was no urgency in doing this.
But according to the Speaker's timelines, according to his calculations from when the motion was tabled at the Senate, the time was supposed to lapse that Saturday. The hearing window was supposed to lapse that Saturday.
And this is why we are saying they have gone to court to challenge that, because under the Constitution, that is not the correct position. They had a chance to continue hearing, and they had a chance to even allow the Deputy President to come and present his own case. Yeah.
Right. Well, those are just some of the sentiments that are happening in our courts, and that particular ruling continues. I mean, that hearing of the impeachment of Deputy President Rigathi Gachagua goes on later on this afternoon. And of course, we are going to be heading back to Milimani Law Courts once that commences. But for now, we're going to take a very short commercial break, but we'll be right back with more.
Unatazama Sound Candy Talk. Toa sauti yako usikike.
Bunge la kitaifa lilikuwa na siku 60 kuweza kujadili pendekezo la Mheshimiwa Rais William Ruto kwa yule ambaye ni mrithi kama naibu wa rais ama mteuliwa. Na lakini anapoulizwa haya maswali, anasahau pia kuuliza hili swali mbele ya mahakama kwamba je, mbona mahakama ina kikao cha masaa marefu wanaenda pumziko la lisali moja, alafu warejee kuhakikisha kwamba wanasikiza kesi hii na kumaliza. Kwa kawaida mahakama zetu hazifanyi kazi hivyo. Unaweza enda mbele ya mahakama kwa swali moja na mahakama itachukua pengine miezi 6 ama hata takriban mwaka mzima kuweza kujadili na kutoa uamuzi wake. Mbona hawajataka kwamba mahakama basi isikae masaa marefu na isiharakishe, ichukue muda utakavyo hata kama ni miezi 6 kutoa uamuzi wake? Katika mvuringo wa masuala ya utawala na maisha hutokea masuala ya kipekee. Swala la kumng'atua mamlakani Rigathi Gachagua ni swala la kipekee, si jambo la kawaida. Swala la bunge kujadili, kupiga kura na kumng'atua Rigathi Gachagua ni swala la kipekee na ni swala la kihistoria. Sasa hivi mahakama inapojadili swala la kuenguliwa kwa Rigathi Gachagua ni swala la kipekee, ni swala la kitaifa, na kuna haja muhimu sana kwamba mahakama ishughulikie kwa msingi ya utaifa na kwa sababu ya umma ambayo ina matarajio makuu sana kwamba swala hili liweze kushughulikiwa na uamuzi utolewe mara moja kwa manufaa ya taifa, manufaa ya siasa, na pia kwamba maswali yasianze kuwa katika fikra za watu kwamba iwapo mahakama itachukua miezi 6, miezi 8 kuweza kusikiza na kutoa uamuzi wake, waseme kwamba pengine mahakama imekuwepo na mwingiliano wa kisiasa ili kuweza kushawishi jinsi ambavyo uamuzi utatolewa. Kwa hivyo pale ambapo mawakili wa Rigathi Gachagua wanauliza maswali muhimu kwamba mbona kulikuwepo na mbio katika masuala haya yote, ni kwa sababu ni masuala ya kipekee. Jinsi ambavyo mahakama iko katika mbio kuhakikisha kwamba inasikiza kwa haja, kwa haki pande zote na kutoa uamuzi kwa muda mfupi uwezekanao, kwa sababu ni swala la kipekee.
Lakini Javas, hapo kwa mbio tumeona mawakili wa walalamishi wa Rigathi Gachagua wakisema hamna haja ya kuwa na mbio. Maana yake kisheria na kikatiba bado taifa lipo sawa. Wametoa mwongozo wakasema hata ikiwa kwa mfano tuko katika hali ambayo hatuna rais wala naibu wa rais, basi yule spika wa bunge huenda akaendesha masuala ya kitaifa. Hivyo basi wanasema katiba ilikuwa imeweka suluhu ambazo zimejipanga sawa sawa. Hivi wakisema kwamba huyu naibu wa rais aliyeng'atuliwa, hili swala lisikilizwe kwa utaratibu, hamna dharura, maana yake bado kuna rais ambaye yupo mamlakani.
Kweli kabisa, na ninaelewa sana hoja hiyo toka upande wa wale ambao wanasema kwamba mbio hizi hazistahili. Naelewa kabisa kwa sababu ya uegemeo wa kisiasa, uegemeo kwa sababu ya kazi ambao wanaitenda ya kisheria, inaeleweka kabisa. Lakini kwa sababu ibara za katiba zimekusudia kwamba kutakuwepo na nafasi katika afisi ya naibu wa rais, kwa mfano jinsi ilivyo sasa hivi, na kwamba kuna muda kwa mfano wa wiki 2 rais kuweza kuteua ama kupendekeza jina, haimaanishi kwamba rais ni lazima asubiri hadi siku ya 14 ndiye apendekeze jina. Kwamba katika hizo siku 14 ana ule uhuru wa kutekeleza majukumu yake. Bunge kuwa na siku 60 haimaanishi kwamba lisubiri hadi siku ya 60 ama siku ya 59 ndiye iweze kujadili na kupiga kura katika ule mtu ambaye alipendekezwa na rais. Ni kwamba katika zile siku 60 huenda pengine bunge likatia dosari jina ambalo limependekezwa na rais na liregeshe jina hilo, na rais ajukumike kwamba ateue, apendekeze jina lingine na aregeshe tena kwenye bunge. Na haimaanishi kwamba ni lazima, kwa mfano ukiangalia katika vyuo vikuu ama hata shule za sekondari kadhalika, pale ambapo mtu amepatiwa masaa 2 kufanya mtihani, haimaanishi kwamba ni lazima hayo masaa 2 yatimizike ndio umalize mtihani huu. Kuna wale umaliza baada ya dakika 30, lisali moja. Inategemea na uwezo wa mtu na jinsi amemakinika na uwepesi wa uelewi. Kwa hivyo katika kusudio la katiba kwamba kuna muda huu ambao umetengwa wa juhudi la kujaza nafasi ambayo iko wazi katika afisi ya naibu wa rais, haimaanishi kwamba ni lazima muda huo wote uweze kutumika. Jambo lingine ukiangalia, sio lazima tuwe na hii desturi na utamaduni wa kuweza kuwa hatuko na wepesi na kuweza kuzubaa na kuvuta miguu yetu katika kutekeleza majukumu. Kwa mfano, acha nikwambie, katika utawala wa Mheshimiwa Rais Uhuru Kenyatta katika uongozi wake awamu ya 4, tume ya haki makamishna walimaliza kazi yao, ikakaa miaka karibu 3 bila makamishna. IEBC katika hatamu hiyo ya Mheshimiwa Uhuru Kenyatta ikakaa bila makamishna kwa kipindi cha karibu miaka 2.5. Isije ikawa ni desturi kwamba afisi za kikatiba zikae wazi, japokuwa katiba haikusudii kwamba nafasi hizo za kikatiba zikae bila mmiliki. Kwa hivyo kuzingatia kwamba tunaweza, ni kama sasa hivi hata IEBC bado haina makamishna. Swala hilo limeanza kuibuka katika mahakama. Inafaa tuwe wepesi wa utendakazi na kwamba tuweze pia kujiuliza kuwa iwapo ilifanyika hapo awali, je, ni lazima sasa iwe ni tamaduni yetu kwamba afisi ya kikatiba inapopata nafasi ambapo kuna mwanya ya kujazwa, je, ni lazima kwamba ikae muda mrefu? Sidhani. Kwa hivyo nikimalizia, naweza sema kwamba ni vyema kwamba tuanze kuwa na desturi mpya ya kufanya kazi katika njia ambayo inafurahisha, njia ambayo ni ya haki na kweli, lakini njia ambayo makusudio ya katiba itakumbatia.
Na ikuwe ni katika sekta zote wakili, isiwe ni katika maswala ya kisiasa ambayo yanahusu wanasiasa. Kwa mfano, tuna hili swali la SHA, bima ya kitaifa nchini, ambayo imeleta utata mwingi. Wakenya wamekuwa wakisema hapa kidogo kuna dosari, tuangalie. Lakini ukiangalia hata rais mwenyewe imemchukua karibu miezi 3 ama 2 kuweza kusema kuhusu SHA. Lakini siku ambayo naibu wake alikuwa anang'atuliwa, aliweza kuandika barua usiku, siku ya Ijumaa.
Naunga 100% tetesi hizo kwamba suala la SHA halijaeleweka kikamilifu na wananchi, na kwamba hata katika utekelezaji wa SHA kumekuwepo na maswali ibuka, kumekuwepo na changamoto nyingi sana. Na nadhani kwamba suala hilo Wizara ya Afya pia inastahili kwamba iweze kuwajibika kuhakikisha kwamba kila Mkenya ambaye anategemea SHA, kwa sababu Wakenya wote wanategemea SHA, suala hili liweze kutatuliwa haraka iwezekanavyo. Ndipo Mheshimiwa Rais nilimsikiza juzi akisema kwamba SHA ni lazima iweze kuhakikisha kwamba inatekelezwa kwa njia ambayo inastahili na inafaa. Na nadhani swala la SHA ni jambo ambalo pia inastahili lipatiwe ile attention ama ule umakini na muda ambao unastahili, ili kwamba ieleweke, ielezwe na pia iweze kufanya kazi kwa njia ambayo inafaulu. Kwa sababu pale ambapo mgonjwa yote anaenda hospitali, ana saratani ama mgonjwa yote hata iwe ni malaria, lazima aweze kupata haki yake, aweze kuhudumiwa na matibabu chini ya SHA. Na pia nadhani pengine pia ningeweza kusema kuwa jambo hili afisi ya msemaji wa serikali inafaa pia ijukumike na iwajibike, ili kwamba katika kueleza jinsi ambavyo sera mbalimbali za serikali, iwe ni SHA, iwe ni masuala ya kawi, yaweze kuelezwa kwa njia ambayo wananchi wote wanatoshelezwa na taarifa zote ambazo zinatoka katika serikali.
Bila shaka na yashughulikiwe na kimo ambacho tunashuhudia sasa hivi.
Kweli kabisa.
Kingine kikuu ambacho mawakili wa Gachagua wameweza kutilia dosari pale mahakamani Milimani ni swala la public participation, na tumeona si wakili moja, karibu 3 wakiingilia swala hili kwa undani na uzito, yani ushirikishi wa umma. Kariuki, nikulete hapa wewe kama kijana, je, ulishuhudia ama ulifanya public participation, ushirikishi wa umma? Na kama ulikuwa pale kijijini pako Murang'a kwa mfano, hilo lilifanyika kwa njia ipi? Mawakili wa Gachagua anasema hilo halikufanyika kwa njia inayostahiki. Ulishuhudia nini?
Unajua, wacha nirudishe Wakenya kwa context ya public participation ilivyo sasa hivi katika sheria zetu na katika katiba yetu. Tukiongea saa hii, hatuna sheria ya wazi or a defined legislative process ya hii public participation. Na nafikiri part of the responsibility ambayo bunge wakiretreat kule Naivasha sahi mahali walipo wanafaa kuwa wakifanya ni kufikiria kuhusu hii sheria ya public participation. Ndio sisi kama Wakenya tuketi chini, tuunganishe mawazo yetu, tuweke a clear term and definition ya public participation. So kwa hii process ya impeachment, hii mawakili wanaleta waki-argue ya kwamba public participation haikufanyika vile wao wangetarajia. Ile swali kubwa tunafaa tuulizane ni kama kwamba kulingana na wao wanatumia which threshold
ya kupima public participation,
kama ile public participation ambayo imekuwa kwa hii process imefika ile ambayo inafaa kuwa imefikiwa. Mimi jibu langu kwa swali hilo ni ya kwamba saa hii tulivyo hakuna threshold ambayo unaweza kutumia useme ati public participation kisheria inafaa kufikia kiwango hiki. Vile vile process ya impeachment, ukiangalia hata huko nyuma mahali ambapo ilitoka, phenomenon ya impeachment ni nini? Ni phenomenon ambayo ililetwa haswa huko nchi ya Uingereza miaka ya 14 something, wakati ambao makings walikuwa wanaweka excesses kwa power yao. Na ule ambaye alileta mambo, nafikiri alikuwa anaitwa Alexander Hamilton, alileta mambo ya impeachment kwa masomo ya siasa. Alisema ya kwamba impeachment processes are supposed to check public officials who betray public trust. So, hii public trust ni nini? Hii public trust ni kwamba kiongozi amechaguliwa na wananchi, amewekwa katika ofisi, lakini hajawajibika na hajafanya kazi kulingana na vile wananchi walitarajia. So tunafaa to exclude in this case the citizenry from the processes yenye inaendelea katika koti. Wakenya wenyewe kwa hiyo public participation ndio wanajibu swali la kama wanahisi ile public trust imekuwa betrayed. Na sasa kujua hiyo ndio tuweke threshold,
tupate kipimo cha kutumia,
tukuwe na kipimo, lakini as we speak hakuna kipimo kama vile mawakili wa Rigathi Gachagua wanaargue.
Sasa hamna kipimo, lakini wakili Njero wa Rigathi Gachagua ameweza kueleza mahakama kwamba stakabadhi za bunge Hansard ambazo zililetwa, Milly Odhiambo mbunge ameweza kudhibitisha kwamba ni Wakenya 200,000 pekee walioweza kufanya public participation, ushiriki wa umma, huku akisema je, hicho kipimo kitawekwa kando na Wakenya milioni 45 ambao hawakuweza kushiriki, hata ingawa hatuna misingi yote kufikia sasa. Lakini je, hilo linaonyesha jinsi ambavyo swala hili lilipokelewa na Wakenya?
Unajua hiyo ni conversation tricky. Tunaweza kuenda on and on in that debate kuhusu ni watu wangapi, ni wapi, lakini kumbuka culture, au rather niseme hivyo, acha ni frame hivi. Unaona leo mahali tuko kama nchi, hizi vitu zote unaona katika siasa zimekuwa kwa sababu ya 1, policy issues, 2, our political culture, 3, sheria zetu. So hawa majudges saa zingine wakifanya decision wanaangalianga what is called political cultures, those doctrines, those policies and those laws. So ile political culture ambayo tuko katika nchi ya Kenya na imekuja ikawekwa kwa sheria ni ya kwamba saa zingine wanaita representation. Hii tunatuma wabunge wanaenda Senate na National Assembly. Hiyo ndio tunaita representation. So tunapatia powers yetu
wao waweze
wa viongozi waende watufanyie hii processes. Sasa swali ni je, bunge sheria inasema watahakikisha wamefanya public participation, but hakuna threshold. But at the same time, hii bunge ambayo sisi tumedelegate power
ya wanawaregeshea
kwa hii bunge, walifanya nini katika hii impeachment process? Wao 85% National Assembly walipiga kura ya kufanya impeachment, Senate the same. So mimi swali kubwa ambalo linatokea kwa hii conversation ya Gachagua, hata si kama hii process yenye imefanyika sahihi ina threshold ya public participation. Swali yangu kubwa ni Rigathi Gachagua anaweza kuwa akienda kutafuta nini katika koti? You know, that is the answer that should be answered.
Tutafika kwa hilo. Wacha tubaki hapa kwa ushiriki wa umma. Javas, mwana sheria wetu. Sasa hawa mawakili wa Rigathi Gachagua walisema jambo ambalo ningependa utufafanulie kisheria. Maanake hata mimi nilikwama kidogo. Wanasema pindi rais alipoteua Kithure Kindiki kama naibu wa rais, aliweza kuandika barua hiyo na kujumulisha tume ya EACC, IEBC na vile bunge la kitaifa. Lakini wanasema pia kulikuwa na haja ya rais vile kutafuta ushiriki wa umma, public participation, katika lile jina la Kindiki Kithure. Tufafanulie hapo kisheria kunaendaje?
Lois, napenda nianze kwa kusema kuwa uhusisho wa watu katika masuala ya utawala ni baadhi ya nguzo muhimu sana za utawala katika ibara ya 10 ibara ndogo ya 2 ya katiba ya Kenya. Na uhusisho wa watu katika mtazamo wa kina, nataka niweze kusema kuwa uhusisho unakuja ama unaweza dhibitishwa kwa njia mbalimbali. Kuna ule uhusisho kwa njia ya kujieleza. Na hiyo tumeona kwamba ilifanyika. Kuna watu ambao walikuwa wanazua tetesi wakipinga kung'atuliwa kwa Rigathi Gachagua. Kuna wale ambao walikuwa wanatoa hotuba wakiunga mkono. Huo ni uhusisho. Kuna wale ambao waliandika nyaraka na wakazituma kwenye bunge. Kuna wale ambao waliandika barua pepe. Kuna wale ambao nyaraka hizo walijaza kupitia tovuti ya bunge. Kwa hivyo hizi zote ni njia mbalimbali na tofauti za uhusisho katika masuala ya uamuzi, katika masuala ya utawala, na haswa katika utendakazi wa masuala ya bunge inavyoelezwa katika ibara ya 118 ya katiba ya Kenya, kwamba bunge katika utekelezaji wa majukumu yake ikiwemo kubuni kwa sheria ni lazima izingatie uhusisho wa wananchi katika majukumu yake. Na kwa hivyo isije ikapeanwa ule mtazamo mdogo kwamba uhusisho huu ni lazima huwe kwa njia pengine ya nyaraka peke yake ama kwa njia ya kuweza kutoa hotuba na kujieleza peke yake. Kwa hivyo njia hizi zote inafaa zijumuishwe. Kwa mfano, upande wa Mlima Kenya anakotoka Rigathi Gachagua, kuna watu ambao walienda katika vikao hivyo wakazua vurugu, wakiimba, wakipinga. Walikuwa wanajihusisha na walikuwa wanatoa sauti yao. Swala ibuka ni je, katika wale ambao hawajatuma maoni yao kwa njia ya nyaraka, tunaweza dhibitisha vipi kwamba walijihusisha kwa njia ambayo inatosheleza? Kutokuwepo kwa sheria ya kitaifa ya masuala ya uhusisho wa wananchi katika utawala pia imeleta upungufu ule, kwa sababu kutokuwepo kwa sheria hiyo hakuja peana mapana ya jinsi ambavyo uhusisho wa wananchi unaweza tosheleza na kipimo cha utoshelezi huo, na pia kueleza muda ambao unafaa ili kwamba taarifa itolewe kwamba uhusisho ama mkutano wa umma ama baraza ama hadhara itakuwa ya katika muda fulani, jambo fulani, na stakabadhi ambazo zinahusisha swala hilo muhimu zitolewe kwa kipindi gani kabla ya mkutano huo wa umma. Kwa hivyo upungufu huu umetokana na kutokuwepo na sheria mwafaka ya kitaifa. Lakini kumbuka kwamba kuna baadhi ya maamuzi mbalimbali za mahakama, zikiwemo mahakama kuu, mahakama ya rufaa, hata mahakama ya upeo, ambazo maamuzi ambazo zimeweza kueleza jinsi ambavyo uhusisho wa wananchi ni muhimu. Tukianza na ile kesi ya Kiambu ya mwaka 2015, tukiangalia kesi ya BBI, kumekuwa na kesi nyingi sana ya masuala ya uhusisho. Na iwapo mawakili wa Rigathi Gachagua watategemea swala hili la uhusisho na jinsi ambavyo unaweza dhibitishwa pakubwa, watakufa maji. Najua kwamba yule ambaye anakufa maji hata tawi la mua atajaribu kushika ili kujaribu kujiokoa. Na hapa iwapo utategemea tu swala la uhusisho wa watu kwamba hiyo ndio dosari kubwa sana, basi huenda ikawa Rigathi pamoja na mawakili wake wanakufa maji.
Na kabla ya kufunga Javas, naomba utufafanulie pia kisheria ni kwamba hapo jana pia naibu wa rais aliyeng'atuliwa Rigathi Gachagua aliweza kuenda katika mahakama ya rufaa akiwa na maombi kwamba mahakama hii kuu haina kiwango ama uwezo wa kuendelea kusikiliza kesi hii. Hilo linaendelea huku haya milimani yakiendelea.
Msingi wa maombi ya Rigathi Gachagua kupitia mawakili wake katika mahakama ya rufaa ni kuwa hajatoshelezwa na uamuzi wa mahakama, jopo hili la majaji watatu mahakama kuu, kuwa hawatajiondoa katika kusikiza kesi hii kwanza. Pili, kwamba naibu jaji mkuu Philomena Mwilu mheshimiwa hana ruhusa na uwezo wa kuteua ama kupendekeza jopo la majaji kusikiza kesi kama hizi. Na swala hilo ndilo ambalo wamepinga. Sasa uamuzi uliotoa wiki iliyopita ndio ambao Rigathi Gachagua ameenda katika mahakama ya rufaa. Mahakama ya rufaa tayari imetoa mwongozo kwamba itasikiza kesi hiyo wiki hii na uende ikasikiza hadi Alhamisi na pengine itoe uamuzi wake Ijumaa. Kwa hivyo hiyo itakuwa inaendelea. Ni swala tu sio kuhusu kesi hizi zote, lakini ni swala kuhusu uamuzi wa mahakama kuu wiki iliyopita.
Asante Javas Bigambo, asante sana Kariuki Ngunjiri. Ni kushukuru pia mtazamaji wangu kuweza kutuagiza macho na masikio kufuatilia hatma ya Gachagua. Kumbuka mahakama ya Kilimani ama mahakama kuu imeenda katika mapumziko mafupi, na pindi tu watakaporejea basi tutakupeperushia yote yatakayojiri milimani moja kwa moja. Kufikia sasa ni kwamba mawakili wa Rigathi Gachagua wameweza kujitetea mbele ya jopo la majaji watatu, na baadaye mahakama itakaporejea upande wa serikali na bunge pia utachukua usukani, na baadaye jopo hilo kuweza kutoa mwongozo wa hatma ya masaibu ya naibu wa rais Rigathi Gachagua, ambaye katika habari za hivi punde kabisa ni kwamba chama cha UDA ambacho ndicho chama walichotumia kama basi ya kuelekea Ikulu kimependekeza kuweza kumondoa naibu wa rais Rigathi Gachagua kama naibu wa chama hicho na kupendekeza Kithure Kindiki. Tunafunga, nasema asante kwa mwaliko wako, lakini endelea kutazama.
Unatazama Sound Candy Talk. Toa sauti.
Mingi sana. Hatuwezi kubali mtu haribu. Kenyans will be shocked. Hiyo Ikulu nimeweka mitego kila kona, kila kona. Hapo iko kibarua. 291 members.
Unatazama Sound Candy Talk. Toa sauti yako usikike.
Sound Candy Talk sasa imeboreshwa zaidi. Kila siku ya wiki asubuhi tunapambazuka na maabudu na sifa kwenye kipindi cha Daybreak Worship. Baadaye tunakuletea mahojiano ya moja kwa moja kwenye one-on-one show. Alafu tunakuletea taarifa zinavyochipuka siku hiyo zikiwa ange kwenye In the News Headlines. Kisha tunaingia bungeni. Viongozi tuliowachagua.
Unatazama Sound Candy Talk. Toa sauti yako usikike.
Say that you have no right to be listening to this particular hearing, what will then happen?
Well, if you are not properly constituted, or rather the appointing authority was not proper, didn't have instructions to maybe appoint you to become to be the free bench to hear the case, and you end up making a decision, then it means that the decision that you have made becomes does not hold.
So what if Kindiki is sworn in? What
So-
will happen? What will
And
happen?
that's why we are seeing everything moving so fast, because one is an appeal ongoing right now that has or rather that was filed yesterday, and we expect to get the information on whether it's being allocated any dates to be heard. And then we already have this one on lifting the conservatory orders. If the conservatory orders were to be lifted, you know, there's a process by which this whole process has to follow. The legal process is, we expect that there is the gazettement of impeached Deputy Gachagua from being the Deputy President of the Republic of Kenya, and then there should be another gazette issued gazetting Professor Abraham Kithure Kindiki as the Deputy President of the Republic
Without
of
public
Kenya.
participation, you may ask?
So we are saying if the conservatory order right now was to be lifted, that's the next move that that we expect from the president.
Okay.
So that will be the next move. And once it is gazetted, the swearing process takes place. But I believe the judges are likely not to hold that decision or to uphold that conservatory order, because there are questions on how the procedure was held at the Senate and at the National Assembly. Was there public participation? Remember in a few years back when we had the handshake conversation, the BBI case, where we went over, the case went all the way to the Supreme Court, and the court found that there was no proper public participation. The initiation of the process of amending the constitution was not properly done, where the members of the Republic of Kenya were the ones to initiate it according to the law. They are the ones who are supposed to initiate it. But in this case, there were a few individuals who went ahead and initiated the process. And so public participation is not as simple as we may want to disregard it. Someone in court said that this is not child play, that the process of impeaching a deputy president should be taken with the seriousness by which it holds. And so part of the seriousness under Article 118 of the Constitution is that there must be public participation process being carried out. And so whenever the Senate, whenever the presidency has to go through the process of appointment. So that public participation has to be held, has to be taken seriously for the people of Kenya who are supreme under Article 1 to give their views. And in this case, the form that was given to the people of Kenya, for example, only had 3 questions where you are to pick. And it did not have the response from the Deputy President, Rigathi Gachagua, stating his case, properly informed as the process was to go on, for you to make a proper decision as you receive these forms, whether he should or should not be impeached. And so public participation is a major issue. And so I don't foresee at all the lifting of the conservatory orders.
All right.
Yeah.
Finally, before we close, moving forward, this particular impeachment case of the deputy president, former deputy president, Rigathi Gachagua, does it prove that, it's even so easy to now impeach a sitting president, if those are some of the, charges that can make a deputy president to be impeached? What does that really tell us into the future?
Into the future, we can only wait and see if tomorrow or the day after, if the 3 bench presided by Honorable Eric Ogola goes ahead and makes a ruling and says that they do not find that the conservatory orders should be lifted. If that is a decision, or if they find that they should be lifted, we have to wait and see their reasoning, because we have said this case is momentous. This case is one that is, would say in class, justice has so much force that we, as the people of Kenya, we can only wait to see the reasoning of the judges. And in making that reason or giving that ruling, it has to also inform the future, what we call a precedent. It has to carry so much weight that in the next cases of impeachment processes, we will keep referring to the decision of a three-judge bench, referring to this process. Was it properly done? What are the days to be given to the parties? Should the impeached party be given a right to be heard? What happens in case they are unwell? So all these decisions need to come into play when this ruling is being issued. And so we can only wait for the decision, but also this is not the finality, because we're going to have, again, hopefully, the parties who might be unhappy might move on to the Court of Appeal and decide to appeal this decision. After that, the party that will be unhappy might move to the Supreme Court and decide to challenge that decision, and the Chief Justice and the Deputy Chief Justice are going to make that major decision that is going to impact our lives as Kenyans on impeachment process.
So clearly it's a wait and see.
It's a wait and see process. We cannot conclude this issue today and expect that there will be a public holiday. Because I know a lot of Kenyans are expecting a public holiday with the swearing in of the Deputy President nominee.
All right. Well, that particular hearing, like I said earlier, is supposed to resume at 3:30 p.m. And as you can see there on your screens, lawyers are actually streaming in, meaning that the hearing will start at any moment from now. As you can see there, that's the Milimani Law Courts here in Nairobi. The sitting is supposed to commence at 3:30 p.m. earlier on during the day. We had petitioners raising pertinent issues in regards to the lifting of conservatory orders of a deputy president or former deputy president conservatory orders, rather, stopping the swearing in of deputy-president-elect, that is Abraham Kithure Kindiki, as well as the arguing the case on that particular process, how it was conducted, saying it really happened in a hurry. 1 minute this is happening, next minute the other is happening, last minute, nomination of Kithure Kindiki there. But of course, that is a case that we are keenly following on. When we resume at 3:30, the respondents are going to be arguing their case. That is the lawyers of Parliament, the lawyers of Professor Kithure Kindiki, and so on and so forth. Those are going to be coming in later at 3:30 p.m. As you can see there. The session is set to commence anytime from now. Lawyers are set in there. What perhaps are we expecting in this afternoon? Perhaps, Eliud, if you can talk to us about it.
What we're expecting this next session is, you as an applicant of any application in court, when you argue your application, you get a response from the other party. Once they respond to that issue, you're given the right to answer whatever they have responded to your issue on. So we now expect the lawyers for the AG, for the president, for the Senate, for the National Assembly to come in and now give responses, because remember, the lawyers for Deputy President Gachagua have already punctured their case. They have raised the issues and said, no, the process was not properly done. There cannot be any vacuum if we have to wait until the full all the petitions are heard. They have argued and said that if in any way we are going to raise or rather the conservatory orders are going to be removed and proceed to swear in the Professor Kindiki, they have argued and said that the process was not properly done, and their cases, the petitions which they have already filed, are going to end up being an academic process, which basically means that they can only be referred to by law students on the process, but they will not have any effect at all to the common mwananchi and to their clients. And so we expect them to come and now answer to all these to all these holes which have been punctured. Let them tell us if there will be a vacuum. What is the interpretation on that? What is their response on that issue? Let them come and tell the court whether, if the conservatory orders are lifted, their cases will be an academic exercise. And so we need to convince the court this afternoon, and the court will be expected to sit back and retire in their offices with their researchers, compare notes, what they have written while they are listening to the two parties, and make a decision, a ruling on whether to lift the conservatory order.
Mhm.
So I expect these lawyers to come out strongly, the lawyers for AG to come strongly and argue back and respond to those issues.
The morning session, if you follow it closely, Senior Counsel Paul Mwite was poking holes on the public participation exercise that was conducted by Parliament, and they were saying the numbers are not adding up. Because perhaps they were saying that the total number of persons in a certain constituency totaling to the ones opposing and the ones supporting it are totally different. That is also what the lawyers of the National Assembly are up to, perhaps to deliberate on?
So we need to justify. Because I had Advocate Elisha Ongoya argue and say that, for instance, there was a station where there were 70 persons who voted yes, but the station had only 40 people who participated in the process. And so what is happening to the math? The math is not mathing, using that lingo that we use in the streets. And so we need to hear genuinely, are the stations which were being referred to for on public participation part of this case? And are they going to affect? Do they feel that they conducted a public participation? Do they feel that the Constitution does not require public participation when it comes to the impeachment process? Do they feel that the timeline given to the members of the public, because remember, the adverts were put in place, and 2 days later, then the responses were put in from the members of the public. Do they feel that that is what the proper process of impeachment should be? And so these are the responses that we expect from the lawyers for the AG and from the from the president to come in and respond to those issues.
So the AG is supposed to convince the judges why they should actually, lift these conservatory orders and have Abraham Kithure Kindiki sworn in.
Yes, we need to show us. Again, the other issue was the urgency. The lawyers for Gachagua are raising the issue of this matter is being rushed and we need to take some time to discuss it. We need to give a fair hearing. We need to give fair trial to the impeached person. And so they need to argue, and we expect them to come in and argue and say, no, he was given a chance. By us making this decision, by Senate making the decision to proceed and vote upon the impeachment, they actually made a decision. They gave him a fair trial. He was given a chance. He did not show up. His lawyer, there are some corners which have argued that since Senior Counsel Paul Mwite was in court, then his existence in the court meant that he should have been the one to represent. He was already representing his client. He should have proceeded to argue and go through the hearing process rather than try and stop it and postpone it to another date. So this is quite interesting to see how they are going to come back and argue and say, no, you are given a proper chance, and therefore the holding by the Senate and the probable nomination of Professor Kithure Kindiki was proper, was properly done, and we do not need to wait for 70-something days for this process to be concluded. So they are coming to tell us.
And that is what the lawyers of Gachagua are arguing on, because they're saying, what is the hurry for? It looks like a predetermined process of actually having this man sent home by, maybe the government.
It's quite interesting to see that. And even the individual petitioners who have filed this case. There's a lady, I believe, Wanjiko, who was in court this morning, and a doctor petitioner who has also filed a case. And this just encourages us as Kenyans that we don't have to wait and instruct a lawyer to appear in court on our behalves to challenge some of those things. That you as a Kenyan, you could sit back, draft your own petition where you feel that your constitutional rights have been infringed upon. The Constitution has not been followed through. This is very encouraging to see that the Constitution has already empowered you as a Kenyan to wake up tomorrow, put in your application, put in your petition, and say that, you know what, I elected this person, or I'm a Kenyan, and I feel that there should be a proper procedure being followed when it comes to impeachment. So that's very encouraging to watch.
So you don't need a lawyer?
You don't need a lawyer. When it comes to public interest cases, when it comes to constitutional matters, you do not require a lawyer. The Constitution already empowers you. You can draft your own petition and appear in court and state that your right as a Kenyan is being infringed upon, that you want to be heard as a Kenyan without going through legal representation. But because the lawyers are the ones who have gone to school, it will be also in order for you to go to a professional and allow the professional also, because they know how to argue and how to go about that, allow them to argue on your own behalf as a Kenyan. Yeah.
All right. And let me take you back to the nomination of Abraham Kithure Kindiki, who is, I don't know whether he's still the Interior Cabinet Secretary. What does the law say about that? Is it that the president is supposed to gazette a notice notifying Kenyans that have received a resignation letter, or Kindiki has tendered in his resignation letter as, you know, a CS, and so what's supposed? Is that supposed to be gone about?
Some quarters have argued and said, according to our Elections Act, a public officer, before they vie for office, they need to resign from that office. And this other quarter is also arguing, there's another quarter that is also arguing and saying, because the Constitution itself, the plain reading of the Constitution, Article 148, does not require all these other procedures to be done. The plain reading is that the president, upon a vacancy coming up, he can nominate and send the name to Parliament, National Assembly, for National Assembly to vote on this person. And so it doesn't matter. And that's the gap that we are seeing. That's the vacuum we are seeing, and the kind of interpretation that we need these courts to give to us. That what happens? Do we still need to look at the nomination of deputy president as if it was an election process, or do we need to look at it as if it's just a prerogative of the president to wake up tomorrow and say, hey, you are qualified, I like you, I think we can work together, yet you're a public officer, or you are, let's say, you do not qualify to serve under that office. So these are some of the issues that need to be clarified by this court.
But where does the weighty issues, where do they put the nomination of Kindiki? Because there's so many. We're having the IEBC, we're having, again, there's supposed to be public participation from Kenyans to, you know, approve or just air out their views for this nominee and so on and so forth. Where does that put the nomination of Kindiki?
Well, it puts it in a very questionable manner because, and that's the argument in court, because one, we're saying there's no proper procedure. We do not have that proper procedure on the vacancy of the deputy president office. It's not clear. We don't have a sub-legislation or a subsidiary legislation apart from the Constitution for us to look at and say, okay, this shall be the steps that shall be taken. We don't have that. What we have in place is the plain reading of the Constitution. But when we look at the wider reading of the Constitution, for example, what I was saying earlier, Article 118, Public Participation, Elections Act on the candidate and how to go about the appointment for this office, and the documents that we now see were presented, the memoranda that was presented to the president. When we look at this, then it becomes questionable how the process was done. How, at the middle of the night, did we have some offices operate? How do we have a body by the name of IEBC, which is not properly constituted, making a decision?
Can the secretarians do that? Does the Constitution allow the current secretarians to do something like that?
The court has, remember when we had the presidential petitions in 2022, what was being argued in court was on the major issues to do with the returning officer for an election of a president. And the chairman of IEBC is the returning officer when it comes to the election of the president and the deputy president. As we stand, or as it stands, we do not have a properly constituted office, IEBC office. If today I was to ask you who is the current chairman of IEBC, because the previous chairman resigned in January 2023.
Yeah, his term came to an end.
His term came to an end.
Yes.
Or rather, he retired because his term came to an end. And so, what happens is we do not have a returning officer for the election of the deputy president and the president. And so, as it stands, then it's improper for us, or we question how this process to vet some of these documents.
So the legality
was done. Yeah.
The legality is now what?
It's questionable. And we go back to the judges. And as it was said by Advocate Elisha Ongoya, that we look to the mountain. We look east of the mountain. And that's what Deputy President Gachagua needs to do. Look to the east of the mountain and just pray that this court will grant him justice.
Right. Like you had said earlier, this is just a wait and see to see how that particular case is going to go about. But as you can see there on the screen, any moment from now, the lawyers are gathered in. They're settled. They're just waiting for the 3-judge bench to see to that they can commence that particular sitting that is set to resume at 3:30 p.m. on the hearing case. Remember, the AG is seeking to lift conservatory orders, stopping the swearing in of Deputy President-elect Abraham Kithure Kindiki. We are keenly following that bit, but we are now going to take a very short commercial break, but don't go too far because we'll be back with more.
Unatazama Sound Candy Talk. Toa sauti yako usikike. Tuko bora kwenye mitandao ya YouTube, Facebook, TikTok na X kwa taarifa tendeti, udadavuzi mwafaka na makala muhimu yanayokuhusu. Tazama Sound Candy Talk upate ufahamu. Kwenye kilele cha Mount Kenya.
Hao watu wasiwadanganye. Finance bill chini. Kwa nini sasa mnataka haya magari na hamkununulia mtu muanze kuchukua pesa?
Hadi mabonde ya Keio Valley.
Ita mkutano na hii watuambie barabara gani tuondoe ndio tusiweke kodi ingine ndio tusiweze kujenga hizi barabara.
Hii ni Sound Candy Talk. Kutoka Bahati Nakuru hadi Bahati Nairobi. Hii ni Sound Candy Talk. Watch, share, like, subscribe.
Sisi vilevile sio watu ambao wanataka ugomvi kwa sababu ya ugomvi.
Niwaambia nyinyi ni wajinga mkimpata Ruto. Mkadhani tunawadanganya.
Jeti ya Ruto. Hii maisha ya Ruto ni stress na ni stress.
Mungu wewe umetukosea. Sasa tumesema siku ya Jumatano. Uko tayari? Uko tayari? Tumesema sisi si majambazi.
Tunaingia vijijini, mijini na hata jijini kukuletea taarifa mchana kutwa. Usiku tunakaa kitako, tunadadavua tukichanganua taarifa na makala muhimu yanayokuhusu wewe na familia yako.
Nasikia watu wanasema baba ametusaliti. Between baba kutusaliti na sisi kusaliti baba, nani amesaliti mwingine?
Inapeangwa, it mostly goes to foreign ministries. So Baba is overqualified for that position.
To build this railways for Africa. So now he's thinking about tumemkataa kama baba wetu.
Unaweza kuwa kuna mtoto ulizaa ukapatia nchi ikuwa inamfanya vile inataka.
Uhuru has been working very hard. Ruto akaenda huko na nguvu. Ruto was never invited in the inauguration.
Ungana na Bernard Ngozi kwenye Open Forum Political Show kuanzia saa 4 usiku hadi dakika zake kila siku ya wiki kwenye Sound Candy Talk.
Open Forum Political Discussion Show. The show that gives an opportunity to air what you feel and think about the latest.
Unatazama Sound Candy Talk. Toa sauti yako usikike.
Justice Madden gave me the order of bail pending arrest. And bail pending arrest became law of the country. It helped very much a lot of people who were being arrested during the time President Moi was in power. My lords, what you have before you, I'm inviting you very respectfully that you have to take into account what is happening in the country. Here it is, Deputy President of the country. The executive is asking for a conservatory order to be lifted. Deputy President is not a small position in the hierarchy of Kenya at all. He has overwhelming political following. Himself and our president, President Ruto, worked together jointly, and they won the election. One of them became president, another one became deputy president. In my view, the two are inseparable. And you cannot take one and leave another one at all. The moment, my lords, you lift the conservatory order, there could be a problem in the country. There could be trouble in the country. Currently, I'm advised the poll rating of our deputy president is 70% in the country. He has won a lot of sympathy votes from those even who didn't like him at all. 70% is quite a big percentage. I've taken the trouble to read the jurisprudence of United States on impeaching. The first country, of course, that came up with the doctrine of impeachment was the United Kingdom. And thereafter, it was taken up by America. And there is a lot of write-ups, a lot of cases where a lot of people have been impeached, a lot of officers of the state have been impeached. But none of them has succeeded at all in impeaching a president. No president in the United States has been ousted because of impeachment at all. We are a young country. We have got our own problems. Problems of extreme poverty. Our people now are wallowing in poverty. They cannot get a meal. Those of us who happen to be in a certain class are lucky. People like Camino can talk about going for lunch. There are some people in this country who can talk about going for lunch at all. Our people are in a very poor kind of situation. We have problems of tribalism. We are still a tribal society. We cannot pretend that we are more sophisticated at all. We have problems to do with the conservation. We have got problems around ourselves. Our neighbors are not doing very well. Somalia, Sudan, and etc. They are not doing very well at all. I am submitting to you very respectfully. These are factors that you cannot afford to ignore. You cannot afford to ignore them at all. And it will be a disaster. It will be devastating for this court to proceed and lift the conservatory order and bring in Professor Kindiki as deputy president. I don't know very much about Professor Kindiki. I have nothing against him. He has never wronged me. And I don't think that he has ever said anything anywhere against me at all. I have nothing against him. But all that we are very much interested in at the moment is to make sure that we have one country. May I remind you, the court, the Honorable Court, very respectfully. Whenever there has been a great departure from the Constitution of Kenya or from constitutional jurisprudence, there has been a problem around. In 1980s, 81 and 82, that's a time when a lot of people were being thrown into detentions. People like Paul Mwite were hiding somewhere else in embassies, I think in embassies, offices, and so on, because of what was happening there to take a cover. I was personally in detention at that time. That is the time when we had a coup in the country. In the year, I think it's 2007, we more or less had also chaos in the country. The point I'm trying to make to you, my honorable judges, what we have before you, a conservatory order, may look a very small matter, but it's a very big issue when it is looked at and is examined, analyzed in relation to the present position in which we have in Kenya. If I may say so, and this, I wish the Attorney General was here, I would tell her very bluntly. Those who want the Deputy President out, let us assume he's kicked out. There will be the same people who will come and say, President, you must go. President Ruto, you must go. There will be the same people who will say that. That will be opening chaos in the country. My lords, these are factors that you cannot ignore. In American jurisprudence, they never ignored that at all. When Clinton was charged with the offense of moving around with Len Whiskey and other women. He had quite a number of women that he was having sexual relationship with and so on. Somehow, as the state continued to adduce evidence, the Americans found that Clinton's becoming more and more popular in the country. Those who wanted to see Clinton impeached had to abandon the idea of impeachment because he was becoming a very, very popular president. And moving him out of the position of president would have brought chaos and misunderstanding in the country. So, my lords, I'm saying to you again very respectfully that please do not try to lift the the conservative order as my land friends are asking for. I hope my little girls have brought my My lady and my lords, the law relating to impeachment is no longer, as I said, a UK affair or an American affair. It touches on the rule of law in a country. It touches on human rights in a country. It touches on democracy in our country. It touches on supremacy of the Constitution, the Bill of Rights, leadership and integrity, separation of power, and the role of the judiciary in administration of justice. My lords, may I, with your permission, read to you one provision from this is referred to Article 150, page 492, a commentary in the Constitution of Kenya, page 150. May I read it to you? 492. This is a commentary in the Kenyan Constitution by our jurists here. And this is what they say. They say some able words which are eye-opener. May I read it with your permission? This article, that is the article that is being referred to, is Article 150, dealing with the removal of Deputy President. This article, which sets out the situation that a Deputy President can be removed, protects the Deputy President from arbitrary decisions. What has been taken here is an arbitrary decision by Parliament, by the Senate, and that should not be taken by the court at all. Arbitrary decision of the President in the field Constitution. If I may pause here, there is a mention of the President. A lot of problems we have had in this country have been caused by the executive, have been caused by the President. We normally have found ourselves in this hostile area because of the acts and behavior of the President. We must tell it as it is. President Moi caused detentions. He acted rashly by putting people in detentions. We have had extrajudicial killings because of the presidency. We have had some other ills because of the presidency. May I continue, please? In the repealed constitution, the vice president could be removed very easily, merely by the instruction of the president. That is true. That's how my great friend and my great client, Jaramogi Oginga Odinga, found himself having to resign because of what was happening. Karanja, Professor Karanja, faced a similar kind of problem. He was kicked out by the president, by the roadside. The vice president could therefore have been said to be at the mercy of the president, who appointed and dismissed them at will. The current state of affairs enables the deputy president to sit a heartbeat away from the presidency, yet enjoy constitutional protection against whimsical section of the president. Let us not forget those wise words, my lords and my lady. I'm inviting you very, very respectfully. Read those words, page 492. And if it becomes necessary, incorporate them even in your own ruling. What is going on now is that the deputy president and the president probably are not getting on very well at all. In my own humble view, for the years I've worked, a person or persons with whom you are working are not always friends. Sometimes you disagree very vehemently, very strongly. You may even end up by probably abusing one another, but you still continue to work. You still continue to work. You do not have to be friends to work together. Husband and wife, is there a problem? Yeah. Husband and wife, and I've handled such cases. Husband and wife may be people who do not get on very well at all. They cook separately, food in the house. They sleep in different rooms and so on. But they have made up one decision. They do not want divorce. They want to make sure that the children are brought up in a family. Russia and America are not getting on very well at all. But if you go to Moscow, you will find American lawyers, American medical doctors, American businessmen. If you go even to New York, the same thing, you'll find Russians. To have a relationship, you do not have to be friends at all. The fact that the president now and the deputy president do not talk to one another, it does not matter. At the beginning, they were talking very well. They were talking to one another very well. Rachel and Rachel and Dorcas were great friends. Some of us were very happy that you could see two wives, two presidents, all of them looking like people of the same family. That is the culture we want. That is civilization we want. That is the peace we want, so that we make sure that we can develop our economy. But not this kind of quarrels and so on, and where one now is able to convince others that we cannot work together, therefore we must divorce. My humble submission, Mr. Lord Eric Ogola, who is you are presiding over the bench, please come up with a judgment or come up with a ruling that you are not going to lift these conservatory orders. If you do so, you will be opening a chapter for this country, which we may not be able to handle at all. Currently, let me remind you again, the deputy president is enjoying poll rating of 70% in the whole country. He has attracted sympathy votes from people who like him. And the Parliament or National Assembly, which actually impeached the Deputy President, if you go through what happened, was a disaster, was disappointing. It is not something to be emulated at all. If you go to the other house, the Senate, again was a disaster. Can I continue, my lord?
Please wind up your submissions.
I'm winding up. I'm winding up. And I'm winding up on this note. My lords and my lady. I have lived enough in this country. I've lived long enough in this country. And in particular in Nairobi. When you hear a rumor, do not be so small-minded and dismiss the rumor at all. The rumor usually has got some truth. So that when you hear Paul Mwita has been bribed, don't dismiss it quickly. There may be truth in it. When you hear Kibe was seen with so-and-so, don't dismiss it very quickly. There may be truth in it. This is the ability that Justice Madden had, and that's why he was able to rise to where he was. The ability to be able to know what's going on in the country and so on. We are a corrupt country, and Besha still controls the country. It controls Parliament. It controls Senate. Let it not be said it controls judiciary. Thank you.
May it please you, Lord President of the court, and the members of your court, we are happy to reply to our colleagues. Somebody has come from the woodworks.
My name is Mosongo. I'm here for John Mariri. Sorry. I was just requesting for 5 minutes.
I'm on high demand. So I beg to leave the court. I'm going to deal with some other matters.
My Lord, just a clarification whether Kituo cha Sheria was enjoined. Last time, Dr. Minwa made an application for Kituo cha Sheria to be enjoined, and then you enjoined Dr. Minwa himself.
Yes, yeah, that was done.
Yeah. Yes, Kituo appears now as seventh interested party. I proceed?
You
5
have
minutes.
Your name?
My name is Mosongo. I proceed?
Yes, please.
Thank you so much. Your Lordship and your Ladyship. At Kituo cha Sheria, our slogan and motto is that we care for justice. Our intention at all times is to uphold the Constitution and ensure access to justice. And we have been, for the past 50 years, been recorded as an organization that promotes that. For sure, I'm not 50 years, but I do stand on the shoulders of giants who have been there before me. And I want to just bring out 5 points in my few minutes. Why you shouldn't vacate the orders or fail to ensure there is conservatory orders. Number one, in promoting justice and the interest of justice, we have petitioners who are saying that the right to fair trial and constitutional rights have been contravened and violated. And it will be so painful for them, genuinely speaking, that conservatory orders be lifted, vacated. Then they continue with the trial. For sure, Article 23, Article 159, Article 27 talks about ensuring equal playground. Our argument is that your lordships and your ladyship, to ensure that their constitutional right to fair trial, even including during this process, so just preserve the few days that you guys will be handling the matter, that status quo be maintained, particularly because it is crucial for public interest.
Judges are not guys.
My apologies. Yes. My apologies. My apologies. Your lordships and your ladyships. Your lordships and your ladyships, if I may proceed. It is indeed in public interest, genuinely, that, and for stability, that for sure status quo be maintained, not only for the current president, vice president, or even the nominee of the president, because it said, ukiona cha mwenzako, kichwa cha mwenzako kimenyolewa, chako kitie maji. It is critical even for future vice presidents, deputy presidents, to have their rights safeguarded, and at least the courts provide a guideline on how Article 145 is to be exercised. And for sure, we also think that and argue that procedural integrity and legal precedent that you are at this point making, your lordships and your ladyship, it is important that the court at least safeguards the petitioners who are claiming their rights have been violated, and they need a conservatory order pending the determination and final outcome, so that it doesn't embarrass the court ultimately when now you make a finding that for sure the entire process could have been flawed. We argue that to also avoid arguments that possibly there would be potential bias, we encourage the lordships and the ladyships to really consider that, as I wind up, that let's ensure that there are no allegations from both sides that justice was not served. It's imperative that at all times justice be seen to be done in line with Article 159. And they have the petitioners that irreparable harm will be occasioned upon them. And it is in the interest of justice that they be accorded that one final bullet, last chance to be able to benefit their rights before the final outcome of this honorable court. I humbly pray that your lordships and your ladyships, please do not vacate the orders. Thank you so much.
Thank you very much, presiding judge and the members of your court. I want to guarantee you from the outset that we will not use 4.5 hours for the respondent. We will be very, very succinct. Indeed, we may very well use half that time. Every lawyer in this court is entitled to his opinion as to what the law is. There is only one thing they are not entitled. It doesn't depend on their opinion. It is what the facts are. That's where we need to start. What are the facts that are relevant to you determining whether conservatory orders should continue in force or should be vacated? It is my humble submission that the material facts are as follows. On the 17th of October 2024, the Speaker of the Senate gazetted the removal from office of the former Deputy President, the Honorable Gachagua, by of Article 157, sub-Article 7. It is important for us to go there, my lord, and it will take half a minute. What is the language of 145, sub-Article 7? It is this: if at least 2/3 of all members of the Senate vote to uphold any impeachment charge, the president shall cease to hold office. That's the language, shall cease to hold office. As at the day and the time and the minute that Senate voted, the deputy president ceased to hold office. I hope this doesn't disappoint my learned friend Teresia Kemodo of Teresia Kemodo and Company Advocates, who wants an apology. The deputy president ceased to hold office. But something else happened. An intervening fact is that on Friday, the 18th of October, via a special sitting of the National Assembly, the Honorable Professor Kindiki Kithure, pursuant to Article 149(1), having been nominated by His Excellency the President, was confirmed by the National Assembly. It voted on his nomination. One person has ceased to hold office, another person has been appointed, has been nominated, and the body entrusted in law in affirming that nomination did so. That was at 1:30 p.m. on Friday, the 18th of October, 2024. What then did the honorable judges of the High Court of Kenya conserve? What were they conserving? There was nothing to conserve. In the logic of the law, we've been told that, a lot about why the Constitution is very important, why it's very special, why it's very transformative, why it's not like the Constitution of other countries. It may very well be all that. But the Constitution is a law to be interpreted the way we interpret all law. When we read a will, we don't start searching for the spirit of the will, because the will is speaking. It is saying, I leave my assets to my son, to my daughter, to my uncle. So a person reading a will doesn't tell the family, before we read the will, let us capture the spirit of the will. If we read a tenancy agreement, we do not say, let us capture the spirit of the tenancy. The tenancy agreement is speaking on its face until there is an ambiguity, which is the same thing with the Constitution. It says what it says until there is an ambiguity. Where is the ambiguity when the Constitution has said, shall cease to hold office? It is our first submission. There is no ambiguity. There is no reason to search for any other meaning, any other spirit, any other constructiveness. The petitioner is aware of that. There is an affidavit here called supplementary affidavit in support of the petition. What does it say in paragraph 22? In this case, however, Kithure Kindiki was unqualified because he had not been a member of UDA political party for 3 months preceding the nomination. He was ineligible for nomination to the elective position of deputy president under Article 37 on the 18th of October 20, when the vacancy arose. This is not the Attorney General's affidavit. It is the petitioner's affidavit. so that his lawyers may be acting contrary to his express instructions, because he has sworn an affidavit in which he acknowledges that that office became vacant. It is our second submission that when the so-called conservatory orders, and my colleagues will demonstrate that these are not conservatory orders, these were mandatory injunctive orders of a nature not contemplated by the Constitution in this circumstance. At 1:31 p.m., when the conservatory orders were issued both in Kerogoya and in Nairobi, there was nothing available to conserve. The substratum of their complaint had been overtaken by events. And so much so, my lords, that, and my learned friends will take you through this, there are several judges who were approached to give conservatory orders, including this bench. And you say there are matters here already overtaken by events. That news may not have reached other parts of the country. Very briefly, I will argue the public interest. My lords, this constitution is a constitution to protect everybody. Sometimes it is cited as if it was tailored only to protect a section of the society in Kenya. It is for everybody, including the institutions that it establishes. It is to protect the judiciary. It is to protect the legislature. It is to protect the executive. We are told continuously that the executive is a problem. The executive is a problem. The executive is also protected by law. The president has a power donated by this constitution to nominate a deputy president. He did that. He has a power to send that name to court, to parliament. He did that. Parliament has a power to vote on that vote. It did that. But it is being suggested that that in itself finds no protection under the Constitution. What finds protection in the Constitution is the conservatory order that came from Kerogoya. Kerogoya, yeah. A place called Kerogoya. We were told, my lord, and this is true, that the impeachment process is a special process. It's sui generis. It is neither civil nor criminal. It's a process sui generis. And that is why, and this cannot be said many times, enough times, that is why the framers of the Constitution do not say that a vice president will be brought to the Supreme Court of Kenya and tried for violations of the Constitution. It is a political process. It goes to a political chamber. Senate sees it as a political body. That's what happens in there. When Dr. Kaminwa says impeachments are never successful in the United States, it is because of the peculiar politics of the United States. Because the impeachment process, even there, is more political than it is here. So we must have fidelity to law, my lords. It is our submission. If you read through the case of Kirero Nguge, it is in our bundle, and I will not. And if you read the case of Martin Wambora, Kirero Nguge is instructive. This is what the court said, and I'll be very brief. A court must satisfy itself that the case before it is not caught up by the bar of non-justiciability. The concept of non-justiciability is comprised of three doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. Thirdly, the ripeness doctrine. Actually, much was said about justiciability. This is not new law. This is old law. It is thousands of years law. It's thousands of years of English law. The first thing the judge would ask is, what is your course of action? You must have a course of action. The court is not a forum where litigants can hold an academic debate. The judge will always ask, what is your course of action? Okay? Now, so the doctrine of justiciability may sound new, but it is as old as the common law. What is the political question doctrine? We are not going to argue it, but it is actually straightforward that the Constitution recognizes that it has donated power and authority to several institutions, and each institution should keep to its lane. We have developed a constitutional law, or we are developing a constitutional law here that actually invites contravention of the Constitution. And it is this, that every conceivable social, political, cultural, economic grievance is capable of a constitutional resolution. How is that? How is that? It is not possible. And that is why in our political social system, we have a million other ways of resolving conflict. Not all conflict is justiciable. Not all grievances are amenable to a constitutional solution. Now, let me go to my second last point about I want to take you to the case of County Government of Kisii and two others versus the Independent Electoral Commission. It is a 2024 decision. And this is the last thing I'll say before I invite my colleagues to come in. The gracious lady will not have to bang her gong. This is what the court said in that matter. While guided and applying the foregoing, in this case, the law does not anticipate that the office of the deputy governor shall remain vacant indefinitely for whatever reason. Having so held that gazettement is a mere administrative formality, and taking into consideration the circumstances of the instant case, whereby nomination and approval by the County Assembly of Kisii was undertaken way back in April 2024, it would be unconstitutional to further delay and postpone indefinitely the filling of the vacancy of the office of the Deputy Governor of Kisii. That's what that court said. Finally, because I'm still within time, the Wajir case shows that our constitution has self-correcting provisions. What happened there, my lords will remember? Yes. Is that the governor had been impeached. During his impeachment, the deputy governor assumed the high office of governor. He went to court. After a long litigation, the court found his impeachment was wrong. And then the court said, reverse the order. Just to use an expression by my learned friend, I think it was Mr. Kiba Mungai, the law is organized. The heavens didn't come down in Wajir. The law said, go back to your office, and the rest of you go home and do something else. That is how to ensure certainty, predictability, stability. That is what we should have here. We are here. I am told on behalf of the Attorney General to assure you that for as long as this matter is litigated, the law will be observed. If a day comes When anything needs to be reversed, that will be reversed. But for now, the public interest is in continuity. Thank you.
Yes, my lord. Your Ladyship and my lords, let me dive right into my submissions, and I will demonstrate, my lords, that contrary to the submissions made by my learned friends, Articles 47, read together with Articles 50 and Article 25(1)(c) on the right to a fair hearing were complied with. And I will show, my lords, that as of the time that notice was received in Senate by the Speaker on the 9th of October 2024, notices were issued to the petitioner to file all the documents as prescribed and to defend himself to every question that was raised in the National Assembly, which, my lord, you recall, had voted by 282 members to impeach the deputy president. The right of fair trial, fair administrative action under Article 47, and the right to a fair hearing were therefore preserved. And I will just demonstrate as I move on to show that once the 16th and the 17th were gazetted as the dates when the deputy president would be heard, and that would be the Wednesday and Thursday of October 2024, the motion, the 7-day period when motions and pleadings were exchanged, then commenced. And all parties were aware that the Senate investigations would take 2 days. Your Ladyship and my lords, parties were then invited to respond to every allegation. This was a two-tier trial, my lords. The National Assembly, sitting as the initial chamber that received the impeachment motion, voting in the affirmative for the impeachment motion, no-brainer. The Senate, as a trial chamber, my lord, Articles 94 and 95, donating powers to Senate and to the National Assembly, respectively. The Senate then proceeded to afford an opportunity. And I want to just demonstrate, my lord, that Article 1(2) of the Constitution designates Senate as the National Assembly as speaking for the people under Article 1, because the people may either exercise their powers directly or through their elected representatives. So my lord must read the Constitution in the sense that the Constitution then, speaking through the people, Senate was the trial chamber that undertook the trial as by the Constitution contemplated. My lord, what happened on the 16th was the commencement of the trial. And it's important to respond to this factual question, that the petitioner participated in the entire trial. Only the petitioner, my lords, had the opportunity to cross-examine all the witnesses presented by the National Assembly that presented his case before the Senate. Senate sitting as a trial chamber as a whole, and therefore as a quasi-judicial body, each senator considered senator prior to the trial. My lords, it was on the 17th, and this is an important distinction. At 2:30 p.m., after Senate had adjourned at 1:15 p.m., that Senior Counsel Paul Mwite presented to Senate an adjournment on the basis that he could not trace the petition of the Deputy President at the time. He informed the Senate that he had learned of his client's illness, but did not reach him. He then sought an adjournment to 5 p.m. He had 2.5 hours to trace his client. My lords, there's a curious point here, and this is important, my lords. The provisions of Article 145, 5 and 6, and I want to refer to those articles, provide, my lord, that at an impeachment hearing before Senate, a party may be represented, 145.5, the president or deputy president shall have the right to appear and be represented before the special committee during investigations. This article was wholly satisfied because the deputy president was present throughout the trial. My lord, then Article 145.6 A and B then step in. If the claims have been substantiated, the Senate shall, after according the president an opportunity to be heard, vote on the impeachment charges. My lord, Senate accorded the deputy president an opportunity to be heard. How was that accorded, my lords? That was accorded, my lord, first to be heard through the pleadings filed in Senate. That is one. But number two, my lord, he was present during the entire presentation of the case by the National Assembly. But third, my lord, he was given and afforded an adjournment at 2:30, from 1 p.m. to 2:30. At 2:30, he was accorded an adjournment to come back at 5 p.m. My lord, what happened at 5 p.m. is summarized at paragraphs 25 to 28 of our submissions, and it goes like this, my lord. At 5 p.m., my lords, the deputy president, the counsel for the deputy president, senior counsel Paul Mwite, submitted or told Senate that he could not trace his client, but that he had been admitted at Care Nostra. He neither presented a medical report nor a report from any doctor. And that is an important observation. But beyond failing to present any document to demonstrate the truthfulness of the health status of the deputy president, my lord, counsel and his team, senior counsel Paul Mwite, eminent counsel Elisha Ongoya, and the entire team proceeded to walk out. And why did they proceed to walk out, my lord? Perhaps they did not read the wording of the Constitution and or the standing orders. Because a party, my lords, may be presented or may be present at trial by himself or through an advocate or representative. In this case, my lord, every opportunity was presented to the respondents to present, but they opted, my lord, not to proceed and not to provide any document to Senate at that point to, my lord, confirm, my lord, at the point that their client or the deputy president in that matter was unwell and admitted. Senate then proceeded, my lords, to vote on that question. My lord, this is where Standing Order 85 comes in, and Rule 6 and 7. I will elaborate. Number one, my lord, under Standing Order 85, senators on a procedural motion may vote by acclamation. That vote was carried and Senate then voted to proceed. My lord, the catch here is Rule 12 of the rules that govern the proceedings. Once the 16th and the 17th of October 2024 were gazetted as the days that we had to proceed, that Senate proceeded, my lord, the proceedings had to be sequential and could not be stopped because of the requirement that the proceedings were time-bound and were to conclude in 10 days. The last day, my lord, that the proceedings were to conclude was the Saturday, the next day. My lord, unfortunately, Senior Counsel Mwite, and the Hansard will demonstrate this, my lord, had applied for an adjournment to the following Tuesday. My lord, we have demonstrated that the petitioner dragged the carpet from his own feet, deliberately decided to sabotage his own appearance when he had been in court for the in Senate for the last 2 days up to 1:15 p.m. before deciding not to be reachable by his entire team and the team making it worse by disappearing. My lords and your leadership, the petitioner had taken part in the cross-examination of all the parties. No case, my lord, has been presented before you that one, there was a violation of the standing orders of Senate. That's number one. Number two, that Senate did not consider some material defense to any of the charges that were proffered against the Deputy President. My lord, I just want to, for clarity of thought, submit that even on the submission that my learned friend, Mr. Masharia, made before this court, that there was additional evidence that was entertained by the Speaker under Rule 6 and 7 by hearing a witness called Mr. Njomo. I remember that submission, my lord. My lord, that was a substantiation of a charge on economic crimes that failed. Only, my lords, 5 out of the 11 charges proffered against the Deputy President petitioner hearing succeeded. Only 5 out of the 11 charges. How else can Senate have been judicious? It threw out 6 charges. None of the petitions brought before you seems to commend Senate for standing its high ground and throwing out 6 of the charges. And that is what good faith would mean, my lord. That out of the 6 charges, my lord, the Deputy President was convicted on the gross violation of Articles 10(2)(ab), 27 and 129 on the shareholding remark. He was also convicted on the other grounds on national cohesion and on the question that is live before this court, my lord, that is on violating his code that requires him to undertake certain function and undermining the function of the National Security Intelligence Service. Ms. Kimotho of Kimotho and Company Advocates would want the Deputy President to apologize on that count. That's a live matter. But my lord, in the grant of conservatory orders, I submit, and this is because I argued Munya, I argued Wajir, I argued Munya, I argued Mate. So I'm an authority in this area, clearly. My lord, on the principles that the court considered, the Supreme Court considered in the Munya case, public interest, I think, bills weighed highest, that this court must take into account the import of a conservatory order issued ex parte against public interest. My lord, this is a country that is built on the Constitution of Kenya 2010 with a president whose powers are defined under Article 131 of the Constitution. And Article 131 as a rider that the president's role as the chief executive of the country shall be performed by himself directly and through delegation by the deputy president. This country, therefore, cannot contemplate an interregnum. That means space of power. An interregnum is not contemplated by the Constitution. The position of the Deputy President, my lords and my lady, must therefore be filled at all times. And that is why the applicants know well that this country must move on and have a Deputy President sworn in because of the dictates of Article 131 of the Constitution. My lady and my lords, a conservatory order is therefore inconceivable in the terms defined in the Munya case. A conservatory order of the nature issued by Justice Mwongo is not only unfeasible, but flies in the face of principles of public interest. The interest in Meru County then was to avoid an interregnum in the governance structure so that Meru County could not collapse. And we took the bold measure to go to court at that time to protect women. This court would only use that authority to support the appointment of His Excellency Honorable Professor Kithure Kindiki, so that this country moves to the second level. I would urge you to discharge the conservatory order on that principle alone, that the wider public interest is greater than the interest of the former Deputy President of the Republic of Kenya. But not wherein would his remedies lie, Malayan Training Body will submit. If it is a salary of 1 month, that would be compensable by damages. If it is a week's salary that is 6 that I should have been or to have been Deputy President, that would be compensated in monetary terms. But this country, my lord, cannot be at a standstill and be held through litigation, because we need to have that position filled. My lord, if I move to the other point, my lord, we have submitted that since every opportunity was accorded to the Deputy President to present his case, and that he failed to present his case, my lord, every argument before this court by my learned friends on the import of the processes of an impeachment fall on their back. They fall on their back, my lord, because the authority in my movie Sonko and Nairobi City County Assembly, and I argued this one, my lord. In part, I was in this matter. In this case, my lord, the impeachment was upheld. In this case, Michael Mbuvi Sonko had sought to fault the process leading to the impeachment because there were no reasons given for the impeachment. The Court of Appeal rightly stating that 1, there was the Hansard that contained reasons. 2, my lord, in terms of an impeachment, my lord, Mike Mbuvi Sonko was challenging the approach where the Senate sat as a whole, as a committee of the whole. The court finding, my lord, that that is an option that is open to Senate and cannot speak to the lawfulness or otherwise. Council on the other side submitted that there was need for a committee. Senate, in its proceedings, my lord, in its wisdom, had voted to proceed through the whole house and accorded the petitioner all his rights that were due to him at the initial stage, only for the petitioner not to avail himself to take advantage of the second opportunity to be had. My lord, we submit, my lord, that unless the processes of Senate are faulted by my learned friends, the impeachment became final when the vote was taken before midnight on the 17th. And His Excellency, the Deputy President, Rigathi Gachagua, stood impeached henceforth. Unfortunately, my lords, this is an impeachment which has no comeback. It is like a death. You have died. You can't come back to life. But you can have certain claims in succession. And that is why we have the law of succession. Rights and remedies then come into question. My lord, set aside the conservatory orders. Let us move on, my lords. The bigger public interest tilts in favor of the appointment of His Excellency Professor Kithure Kindiki, a very good man. Thank you, my lords.
Thank you.
and my lady, my name is Modomi Nkolu for the second interested party. And to that end, we have filed a notice of preliminary objection dated the 24th of October, the year 2024. We have, in addition to that, filed a list and battle of authorities on that preliminary objection. And that list and battle is dated the 25th day of October, 2024. And pursuant to your directions, those are the battles, my lord. I would suggest you hold them close to you because I'll be referring to them shortly. We have, in addition, filed written submissions, skeleton submissions dated the 27th day of October 2024. Before I delve into the PO, my lord, a suggestion was made to you. I had forgotten to tell you, my lord, that I appear for the second interested party together with my learned friend, Mr. Stephen Ogola. Before I go to the PO, my lord, a number of things were said by my friends and learned friends. I mean it because we are both friends in addition to being learned. One of the things you were told is to laugh at me for raising this PO. The other thing you were told is that the PO was determined in some rulings and directions you issued. And our simple answer, my lord, is that unless I'm mistaken, observations made by the court at the ex parte stage before full benefit of argument from all sides cannot be the subject of a submission that the issue is settled. But if you listen to me, why we have raised this PO, and you find that I deserve to be laughed at, it's okay. My lord, our PO makes only 3 interrelated points. The point number 1, which you'll find in paragraph 1 of our written submission, is that the High Court's jurisdiction under Article 23, which governs human rights litigation, and Article 165, which is about enforcement of the Constitution, to confirm whether anything. I'm here to tell you very shortly, my lords, the word anything does not actually mean anything in the literal sense, and specifically to tell you that your jurisdiction under that Article 165 does not extend to disputes as to the impeachment of the president and the deputy president. Yes, the court has jurisdiction to enforce human rights. The court has jurisdiction to confirm whether anything allegedly done in the name of the Constitution is constitutional, but our submission is that that apparently very broad jurisdiction does not extend to a dispute as to the impeachment of the president or the deputy president of the republic. And that is the point made in paragraphs 1 all the way to 7 of our preliminary objection. Number 2, point number 2. This court, and indeed all other courts of the Republic of Kenya, have no jurisdiction to entertain a dispute as to the impeachment of the president and the deputy president. But if we are wrong in that submission, my lord, because I have been wrong many times, we make the submission that the only court that would conceivably, arguably, mark my words, conceivably and arguably have jurisdiction on this dispute is the Supreme Court. And that is the subject of paragraph 8 of our preliminary objection. My Lord, why do we say that this court, though we acknowledge its broad jurisdiction under Article 23 and 165, does not extend to presidential impeachment disputes? The reasons, my lords, are set in paragraph 6 of our submissions. And the simple point is this, that our constitution denies this court, the High Court jurisdiction, on countless matters that would fall under Chapter 4 on the Bill of Rights. Case in point, presidential elections involve human rights under Article 38. It is clear in the Constitution that this court has no jurisdiction over a dispute relating to a presidential election. Even if someone were to come here and say that he was denied his Article 38, which is a human right under that election. My lord, it is clear by dint of Article 58, sub-Article 5, that this court has no jurisdiction to hear a dispute as to a declaration of a state of emergency. My lord and friend, Mr. Ongoya, talks of the word decency. We are all sufficiently decent to acknowledge that nothing invades the entire regime of human rights than a declaration of emergency. That declaration can affect the right to assembly, to expression, to basically everything. And yet the Constitution is clear. If you have a dispute as to that matter, never mind that it has abrogated the entire Bill of Rights, the court you go to is not the High Court. It is the Supreme Court. My lord, property is a matter of the Bill of Rights, Article 40. It is clear from our Article 162 that if you have a problem in that regard, or to do with the environment, which is also a human rights matter, you go to the Environment and Land Court. So, my lord, I'm here very humbly to tell you, the mere fact that someone has run to you screaming Article 23, Article 165, does not without more mean that this court has jurisdiction to hear that matter. In other words, my lord, for you to exercise jurisdiction over this matter, you've been told many matters, and as far as we are concerned, the matter before you, the substratum, is the impeachment. These things you're being told about Professor Kindiki are diversionaries or subsidiaries, because without the impeachment, we will not be talking about Kindiki. So the substratum of the dispute before you is impeachment. And our point, my lord, in the absence of an express grant of jurisdiction on this court, on the substratum of this dispute, on the subject of this dispute, which reminds me of Professor Githu Muigei's issue about justiciability, then you have no jurisdiction. Luckily, my lord, I hope we all agree that there is no clause of our Constitution that confers on this court jurisdiction to entertain the dispute before you, which means, therefore, the question is whether nonetheless you have that jurisdiction, given your broad powers under Article 23 and 165. Luckily, my lord, our Constitution was the product of a 20-year process that we call the constitutional process. And because it is in black and white, I invite you to go to page 5 of our Bardo, my lord, the Bardo of Authorities. We have produced you, or rather before you, extracts of the Bombers constitutional, the Bombers draft constitution. It confirms to us, if you go to page 6 with me, that during the constitutional process, Kenyans actually agonized over whether this matter should be handled in the courts and which court. And it's there in black and white, Article 187 on page 6. It says the Supreme Court shall have exclusive, that must mean to the exclusion of every other court, including this one. Roman 2, disputes arising from the process of the impeachment of the president. So when we were having our debates through the Bombers process, there was a decision, it's there in black and white, that there will be judicial review, not before this court, but in the Supreme Court. Of course, we know, my lords, the Bombers draft was one of many. The next draft that was generated in that process is at page 7 of our BADO, the harmonized draft constitution. At page 8, again, clause 201 of that draft constitution, it is clear there in Article 201, sub-Article 4, that the Supreme Court has, paragraph A, exclusive, at the line, exclusive. We move from that document, and luckily, my lords, the bench, to me, should be familiar with this process, to a document that went to the 2005 referendum, which was the WACO draft. We have produced it at page 10 of our BADO. This document is special, my lord, in the sense that it was subjected to a referendum before the people of Kenya. And again, you'll find there, Article 184, Kenyans were still toying with the idea that the courts can interfere with this process. But what I want you to mark again on page 11 is that the court that had been envisioned is the Supreme Court, not the High Court. We all, of course, know that draft was rejected by the people of Kenya, and that must mean, because this is the draft that reached the referendum, that the people of Kenya also rejected this rule of judicial intervention in this problem before you. Why do I say so? The next document is now the official constitution we have today, which is the Constitution of Kenya 2010. And it has no clause conferring jurisdiction on this court or even the Supreme Court. And since that rule was always on the table, my lord, but was dropped from the final draft, we must take it that the final decision the people of Kenya made at the referendum of 2010 was that there will be no judicial intervention in the dispute of the nature before you. You are told that we have cited Article 144. Yet it is irrelevant. Let's see shortly whether it's irrelevant. We have produced Article 144 on page 13 of our BADO. Two routes, either the route of Article 144 or Article 145. We are only mentioning 144 to help us answer, in the absence of express jurisdiction, whether there is inferred jurisdiction. And when you check 144, one of the curious rules it tells you, 144, Article 144(8) of our Constitution, is that the report of the tribunal shall be final and not subject to appeal. And if the tribunal reports that the president is capable of performing the functions of the office, the speaker shall also communicate. And of course, it goes on to hold that if it finds the president is either insane or suffers an infirmity of body, then the Senate shall vote. Something curious here, my lord, that our Senate can vote to retain a president found by a medical tribunal to be insane, and our Constitution says that decision cannot be challenged in any court or tribunal. Those are not my words. But more curiously, this rule is also repeated, my lord, in Article 165, And for me, what is notable, my Lord, is, the Constitution speaks to an issue once. It has spoken about this issue of 144 in 144.9. And when you go to 165 again, it says this court has jurisdiction to hear an appeal from a tribunal on removal from office, except the tribunal under 144. I don't know, but it must count for something that those who drafted our constitution decided to deny jurisdiction not just once, but twice. So the million-dollar question, my Lord, if this court has been denied jurisdiction twice for the process under Article 144, on what basis can it assume jurisdiction for a process under Article 145 in the absence of express conferment of that jurisdiction and in the face of the multiple ousters I took you through, where the Constitution says in black and white, this matter may be about the Constitution, this matter may be about the Bill of Rights, but the High Court has no jurisdiction. That's what we mean when we say in our PO, my Lord, that there is Supreme Court jurisprudence in this country. I'm addressing you now on the authority in advisory opinion number 2, I believe, of 2011. I don't know whether Professor Tom Ojeda was involved. But my Lord, we were told in that decision that jurisdiction cannot be arrogated through the craft of interpretation. What the petitioner and those in support of his cause are inviting the High Court to do is to arrogate to itself jurisdiction of a dispute or by the impeachment of the president through the craft of interpretation, through the craft of stealth, through the craft of sophistry. Jurisdiction is something the court either has or does not have. It cannot be inferred. Professor Gender is telling me other things one must either have or not have. There is no middle ground. But I suppose he wants me to fall into trouble with the court, so I won't mention them. My Lord, let's go to the decision in Nixon versus United States, which is at page 20. Again, you are told to laugh at me because this decision is from the 19th century. I will invite you to note it's a decision issued in the year 1993. I was in upper primary school in 1993, and my students say I'm still fairly young. So this is not a decision from the 19th century, my Lord. But I also want to point to you, 1993 is so recent, coming from the United States, a country that has had a constitution running for close to 300 years now and counting. Why this decision is important, my Lord, is several reasons. One, it is a decision from the United States Supreme Court. Two, our law on impeachment, and I hope again we have to quote my good friend Ongoya, the decency to agree that it is from the United States Constitution we borrowed Article 144 and 145. Even if you take the rule now in issue, Rule 11 here, Rule 11 in this decision of the Senate. So this decision, to the extent that it comes from the highest court of the country from which we got this idea now before you of impeachment, must surely be persuasive, even if not binding on you. But more important, it is also about impeachment. What happened in this decision, my Lord, is quite interesting. The person who had been impeached was a judge of a federal court in the US. He was sent to prison, but refused to resign from his judicial office. And because in the US, judges hold office for life, to the extent that he refused to resign, It meant the US Treasury was bound to continue paying his salary and emoluments while he was in jail. And of course, that absurdity was not going to be let go. The United States Parliament, called Congress, the House of Representatives, and the Senate took up impeachment and impeached this judge. But when you follow the holdings in this case, my lord, they say at page 20 of our Badu that a controversy is non-justiciable where there is a textually demonstrable constitutional commitment of the issue to a coordinate political department of government, or when you lack judicially discoverable or manageable standards or remedies for resolving it. I don't need to belabor the point. When you read the case, the Sonko case and the Wabora case, that is exactly what our Supreme Court has said. Following this decision that impeachment is textually committed. Those are not my words. They are the words of the Supreme Court of the US, the Supreme Court of the Republic of Kenya. And my lord, we submit under Article 144, or rather 145, impeachment is textually committed to the Senate. But they also say the language and structure of the Constitution confirm that textual commitment of this dispute. More importantly, which is what the Attorney General Emeritus Professor Muige, if you go to page 21, my lord, you are told justiciability is also refuted by the lack of finality inherent in exposing the country's political life, particularly if the president were impeached to months or perhaps years of chaos during judicial review of Senate. We already know, I've been telling you how the other side wants to grind the wheels. We are told by the Supreme Court, my lord, this specter of the country being held on tenterhooks as this matter is fought here, is fought in the Court of Appeal. The average lifespan of a case in our Court of Appeal is 3 to 5 years, the last time I checked. Then going to the Supreme Court, we are being told the political life of a country cannot be held at ransom awaiting judicial determination. And more importantly, lastly, because my seniors are telling me I've been talking too much, so that I take my seat before they reprimand me, I want to refer you to page 32 of our Badu. And the reason I'm referring it to you, my lord, is many people will genuinely be shocked by this idea that a dispute like this is not justiciable, but there are good policy reasons for it. And if you read our page 32, which is that decision in Nixon versus United States, it tells you in black and white, there are sufficient safeguards embedded in the Constitution, including majorities, minimum voting thresholds required at every stage of that process, including the holding of a trial, including calling and cross-examination of witnesses. And because those safeguards, especially at the Senate, are in the nature of a trial, that's why Chief Justice Rehnquist tells us here that nobody should have to make every weather of the idea that this type of dispute is not justiciable. Lastly, you are told about political question doctrine and many things. I will invite you to note the courts of Kenya endorsed this doctrine as early as 2005. Again, the authority is on page 51 of our Bado. I don't have time to take you through it. We have produced the Sonko decisions. We have the citations, the quotes we've lifted in our written submissions. And all we are telling you, my lord, when all is said and done, is to do either of two things. Hold, you have no jurisdiction. The consequence would be that these petitions must be struck out. The conservatory order must fall by the wayside, having been issued by a court lacking jurisdiction. But if my lords find that too heavy and too radical, and therefore unacceptable to this court, I am giving you the alternative if we must infer jurisdiction, because that's what you're being asked, let's infer it at the Supreme Court, which is the global practice, so that the matter is held of this nature is handled once and for all without subjecting the country's political life. That is the public interest we have just been told from the Supreme Court of the United States. That's all, unless there is a question for me.
Thank you.
My Lord, my lady, if it may please you, my name is Milimo. My Lord, I'm here to address you on 3 grounds. Specifically, my Lord, one on public participation. The second issue, my Lord, I'll be addressing you on is fair hearing, with reference, my Lord, to the National Assembly. And lastly, on the nominee, my Lord, the deputy presidential nominee. My Lord, on the first point of public participation, you shall note first, my Lord, that there is no one in the petition before you who has alleged that they were denied an opportunity to participate in the public participation exercise. The second point, my Lord, is that it's common ground to all the parties that public participation was an essential ingredient in the impeachment proceedings. And that is, my Lord, dictated by Article 118B of the Constitution. And my Lord, on the boxes to be ticked in reference to the public participation exercise, I invite you, my Lord, to refer to the Supreme Court BAT decision. And specifically, my Lord, at page 45 of that decision, which we have attached, my Lord, to the first respondent's supplementary list and bundle of authorities, dated 28th of this month. My Lord, the second authority that I will refer you to on matters public participation is the recent authority, my Lord, that was rendered last week by the High Court in the affordable housing decision, my Lord, that is petition number A154 of 2024. And specifically, my Lord, at pages 178 to 179, rather to 184 of that decision. My Lord, if you are to refer to the replying affidavit of the National Assembly, you will note that the National Assembly, my Lord, undertook an unprecedented public participation exercise. None of that nature and magnitude, my Lord, has been undertaken in the history of this country. And my Lord, I'll refer you to the annexed public participation report, and specifically, my Lord, at pages 427 to 555 of the replying affidavit of the National Assembly. And my Lord, very quickly, you note that over 224,000 people my Lord, over 224,000 people were involved in the exercise, where they volunteered to give their views. And out of those, my Lord, you shall note that 65% of the people who rendered their views were in support of the motion.
Is this submission for the lifting of orders or for petition?
My Lord, I'm trying to establish the fact that heavy weather was made, my Lord, on the fact that there was no public
We have
participation.
noted those heavy weathers, but you know, we need to be, because we are all lawyers and judges, we need to be specific to the issue before the courts. Some of the things which you say here are actually not meant for this forum. We've been trying not to intervene, but you know very well that a lot of submissions which have been made here are not for the proceedings today. They are meant for another proceeding altogether. So if you can just avoid them, the better for us.
Yes, my Lord, I stand guided. And then that...
In other words, Mr. Milimo, you may spare us the submission on the sufficiency of the public participation.
Correct, my Lord. Yes, my Lord, I stand guided. And I was just going, my Lord, to refer you to one authority that we had, my Lord, attached as authority number 1 in the supplementary list of authorities. If you are to look at page 4 of that authority, my Lord, the sufficiency or otherwise of public participation exercise, my Lord, is to be determined at the main trial. And my Lord, therefore, I would agree with you that all I need to do, my Lord, is to refer you to the report that I've indicated, my Lord, that it appears at page 427, specifically the findings, my Lord, to 455 of the replying affidavit. But my Lord, allow me just to pick one thing out of that report. You are particularly, my Lord, referred to one of the constituencies, specifically, my Lord, Keio South constituency, where my learned colleagues, my Lord, raised issues that indeed the figures did not tally. My Lord, first, you shall note that the figures that were quoted by the petitioners, my Lord, are contained nowhere in the public participation report that have been submitted before you. My Lord, I want to believe that my learned colleagues got that information from sources other than the report that was submitted at the National Assembly. My Lord, Keio South views, my Lord, are submitted to be found firstly at page 289 of the report, my Lord, and it appears as item number 95. And this goes specifically, my Lord, to the hand-delivered and email views, where it was indicated that, my Lord, there was a total of 465 responses, and out of those, my Lord, 455 were in support. That is what, my Lord, is contained in the report as the first limb. The second limb, my Lord, is for those who participated in the public hearings of the 4th, my Lord, of October, and is found at page 331. Same Keio South constituency. And my Lord, it's indicated that a total of 355 people did, my Lord, attend that public hearing. And out of those, 352 persons, my Lord, supported the motion. Lastly, on that point, my Lord, is to refer you to page 440 of the replying affidavit, my Lord, where you shall note, not 440, my Lord, I'm sorry, page 439, where, my Lord, you shall note that the total responses in respect of Keio South constituency were 820. And that out of those, my Lord, in support were 807. So, my Lord, the views are submitted, or the submissions are submitted by my Lord colleagues, my Lord, do not find any favor in the report. And therefore, my Lord, I'll urge you that you do ignore them. My Lord, I also need to point out that public participation, my Lord, is not a referendum. As well understood, my Lord. And that in the words, my Lord, of your learned brother, justice and sisters, my Lord, in the affordable housing decision, public participation does not, my Lord, necessarily mean that everyone in the country must give their opinions. My Lord, that is paragraph 175 of the affordable housing decision. And that, my Lord, all that the National Assembly was required to do at paragraph 176 is to give the public an opportunity, my Lord, to submit. that was raised was by my learned colleague, Mr. Omari, on public participation, where he indicated, my lord, that elections are conducted at the polling stations. My lord, that submission is not true. The presidential, my lord, elections are provided for in terms of being conducted, my lord, at Article 138(2), where it states, my lord, that the elections are at the constituency level and not at the polling station. My lord, the other issue that arose from the submissions from my learned colleagues is whether, my lord, the first petitioner was given an opportunity to present his reply to the public prior to the public participation. My lord, my answer to that is simple. That first, my lord, the public participation exercise commenced on 2nd of October all the way to 5th. And my lord, by the time the public participation commenced, the first petitioner had not submitted his response or lodged his response to the National Assembly. And therefore, there's no way, my lord, that response could have been availed to the public. Secondly, that, my lord, the National Assembly only avails what is in its possession. And therefore, at that point, my lord, the National Assembly could not have been accused of not, my lord, presenting to the public what had not presented to it. But more important, my lord, there is no legal requirement, and none was cited by our learned colleague, that dictates that the National Assembly had a duty to present, my lord, that response to the public during public participation. And last, my lord, nothing stopped the first petitioner, my lord, from himself presenting that response to the public, as he did, my lord, on the eve of the hearing or proceedings at the National Assembly. The last point, my lord, on public participation was whether, my lord, the Senate ought to have conducted the public participation exercise. And my lord, my answer to that is this, that under Article 118B, my lord, of the Constitution, Parliament is, yes, required to conduct public participation. But, my lord, Parliament under Article 93(1) refers to both the Senate and the National Assembly. And, my lord, you shall note that the impeachment proceedings are two-tier. That the first stage, my lord, is conducted by the National Assembly, and the second one, the trial chamber, is the Senate. The Senate sits as a quasi-judicial organ, my lord, in respect of the impeachment proceedings, and that it's not required to repeat the public participation exercise. Because if that were to be so, my lord, then it means that even this court sitting in exercise of a judicial function, it could be required, my lord, to undertake the public participation
Mr.
exercise.
Melema, we only entertained you on these submissions because we had entertained other people earlier. That is the only reason we're listening to you.
I thank you, my lord. But I'm winding up on that, my lord. Yes. My lord, the second issue that, my lord, I'll invite your attention to is on the subject, my lord, of fair hearing. My lord, and on that limb, there was a challenge, my lord, to the standing orders of the National Assembly. My lord, my answer to that is simple, that there is a presumption of constitutionality of those standing orders, my lord, and that at this stage, being an intellectual stage, this court, my lord, has no power to invalidate those standing orders, my lord. In the fullness of time during, my lord, the main hearing, we shall demonstrate to you that those standing orders, my lord, reflect Article 145 and 150 of the Constitution, and that their simple duty, my lord, is to implement those articles of the Constitution. The other issue, my lord, that was raised was about impartiality of the Speaker of the National Assembly, my lord. Yes, and my lord, you shall note that the Speaker of the National Assembly, my lord, has no vote in the proceedings, and that is, my lord, under Article 122(2)(a) of the Constitution, and that submission, therefore, my lord, is not a valid submission. And my lord, more importantly, my lord, you shall note also that at the National Assembly, the first petitioner was given an opportunity to both appear and be heard. And my lord, he did file a substantive response to the notice of motion. And more importantly, my lord, he was given 2 hours to present oral representations. That opportunity he took, my lord. And therefore, the question of there having, my lord, been a breach on the elements of fair hearing does not arise whatsoever or at all. My lord, my last point is on the nomination, my lord, of my good teacher, Professor Kindiki. And my lord, the issues at the National Assembly, and whether, my lord, there ought to have been public participation as well as, my lord, the timelines that were invoked, my lord, to process the good professor. Yes, my lord, all I need, my lord, to bring to your attention is there was a ruling, my lord, by the Speaker of the National Assembly that we attached to the first respondent supplemental list and band of authorities, dated, my lord, the 28th of October this year. And my lord, you shall note that in that communication, the Speaker did address all those issues, my lord. The communication, my lord, is communication number 54 of 2024, and it's dated the 18th October 2024, where, my lord, the Speaker did address in giving guidance to the House all those issues, and I will invite you, my lord, to refer to it when you retire. My colleague, Mr. Macharia, my lord, on a light note, told the court that, my lord, I would have said Weta Tosha. My lord, I'll say that in 2032 when the right comes. I thank you, my lord, unless the lordship have any questions.
Thank you.
My lords and my lady, I'll proceed from where my learned friend Mr. Midima stopped. Permit me, for completeness of record, to say that the second respondent has filed an application dated the 18th of October 2022. We have filed submissions in support of that application, again dated the 18th of October 2022. And we have a replying affidavit sworn by one Samuel Joroge on the 21st of October 2024. My lords, we also have submissions in response to the application seeking conservatory orders dated the 27th of October 2024. And finally, the list and digest authorities dated 27th of October 2024. I'm reminded by my colleagues that I forgot to mention my name for completeness of record. My name is Eric Gumbo. Well, that said, I would want to start by bringing all of us to the same pedestal in understanding the application and the prayers that are currently live before the court. Permit me to draw your attention to the application filed by our learned colleagues in the matter 565 of 2024 for just one purpose only. The application has a total of about 13 prayers. The prayer number 1 all the way to prayer number 10 have been spent. In other words, they've been overtaken by events. The last prayer, which perhaps would have been relevant for purpose of understanding what I'm trying to get to, is prayer number 9, which talks about that pending the hearing and determination of a petition, a conservatory order restraining the National Assembly of Kenya from discussing, vetting, voting, and or approving the nomination of a person submitted to the National Assembly made on the 18th of October 2024 by the President of the Republic of Kenya, His Excellency William Samoei Ruto, to fill the vacancy of the office of the Deputy President of the Republic of Kenya. That prayer is equally overtaken by events. The last prayer is for deletion of what they call falsehoods to various persons and institutions. It then follows, my lords and my lady, that the petitioner, His Excellency Rigathi Gachagua, has no prayer that is live before you in relation to the question of conservatory order. Looking at the application number E015, the only prayer that is live before you is prayer number C and prayer number E, both of which deal with the question of swearing in of the second interested party appointed by the President and approved by the National Assembly, they say, from assuming the office of the Deputy President. It then is our submission that the threshold question, the arguability question, the negatory question needs to then address the issue of swearing in. I will then straight go to the issue of swearing in. My lords and my lady, we've spoken to the provisions of Article 145.7. 145.7 very clearly indicates that if at least 2/3 of the members of the Senate vote to uphold any impeachment charge, the President shall cease to hold office. May I add to the submissions that have been made previously that that provision is a self-executing provision. You do not need more. It is not an action of the Senate, it is an action of the Constitution itself. The first question that then we would want to ask ourselves this afternoon is, in light of view of such an express provision of the Constitution, is it tenable that an order of this court would issue to stop it? Let me take as one step further to remind us that at the point at which the Deputy President was impeached, he then acquired a constitutional blemish. And they say a constitutional blemish because under the provisions of Article 150, all the charges that were substantiated as against him, including the question of gross violation of the provisions of this Constitution, serious reasons to believe that the Deputy President committed a crime under the national or international law, and gross misconduct, then were issues that would be said to have informed his constitutional standing. Now, where am I going with that? I'm trying to make the point that when the Constitution, therefore, has put a dot or a blemish on you, then certainly you become unsuitable to hold office by dint of Chapter 6 of our Constitution. That is, specifically, I would draw your attentions to the provisions of Article 73, Subarticle 1, which says, talks about leadership and integrity, responsibility of leadership. It says, authority assigned to a state officer is a public trust to be exercised in a manner that, 3, brings honor to the nation and dignity of the office. To the extent that those grounds were established under Article 150, it simply means that the person of His Excellency the Deputy President therefore lost the capacity. And why that is important is then as you consider this question as to whether to grant the conservatory orders or not, would he be one person who would possibly be considered for that situation? And our answer is a simple no. Permit me to speak to the issue of now Article 149. Article 149 reads, within 14 days after vacancy in the office of a deputy president arises, the president shall nominate a person to fill the vacancy and the National Assembly shall vote on the nomination within 60 days after receiving it. First point I would want to make, just to complement what my learned friend Mr. Mudomi has spoken to, as to the justiciability. If the Constitution says that within 14 days of coming into play of Article 145(7), is it practical, is it tenable that within those 14 days, if a party were to have come to court, then going through the hierarchy of the High Court, the Court of Appeal, and the Supreme Court, any dispute touching on that question of nomination would have been resolved? That then speaks to the architecture of our Constitution, to the extent that it is not contemplated that the person who has been impeached would therefore be able to run or even express interest for nomination for purposes of Article 149. Let me then take it one step further to relate Article 149 and 148. In particular, let me start this conversation from one step behind. Our Constitution at Article 1, Subarticle 2, speaks to how our sovereign power is to be exercised. In particular, it says the people may exercise their sovereign power either directly or through their democratically elected representatives. Now, we then relate this to the events of first Article 94, Subarticle 2, which says the role of Parliament shall be Parliament manifests the diversity of the nation, represents the will of the people, and exercises their sovereignty. What point am I trying to make? A lot of heavy weather has been made about the candidate who has been presented for purposes of approval under this Constitution. Now, one of the issues that has been raised is that there was no public participation in relation to the candidature of Professor Kithure Kindiki. My lords and my lady, allow me to just take us very quickly to the provisions of Article 149 to provide some bit of context. That within 14 days, allow me to just read it again, within 14 days after a vacancy in the office of a deputy president arises, the president shall nominate a person to fill the vacancy and the National Assembly shall vote on the nomination within 60 days. Vote is the word used. I want to persuade you, my lords and my lady, that the action that the members of the National Assembly would be taking pursuant to this 149(9) flows from the delegated authority under Article 1, Subarticle 2. It also flows to the role of parliamentarians under Article 94, Subarticle 2, to exercise the will of the people of Kenya, to exercise their sovereignty. In other words, that is a choice that the National Assembly is making as the representatives of their people. And why that is important is the very question that follows, is when making that decision, is public participation an imperative? Our answer, my lords and my lady, is a straight no. And so that then I give you context. Let me give us what happens in the ordinary elections, and which will be at Article 148. Article 148, Subarticle 1 reads, each candidate in a presidential election shall nominate a person who is qualified for nomination for election as president as a candidate for deputy president. Then it adds at Sabbatical 2 that for purposes of Clause 1, there shall be no separate nomination process for the deputy president, and Article 137 1D shall not apply to the candidate of the deputy president. What then do we read from that? It means that a simple reading of Article 148, which is what happens in our ordinary elections, does not call for public participation for the position of the nominated person to occupy the office of the deputy president. Now, if we are to agree, and we have seen it in real life, that is what happens. We don't then subject them to public views around what people think about them, sending memorandum. Once that nomination is done, there is no more that follows other than the declaration after the election itself. Now, why is this important? It is important because of a submission that was made earlier in relation to other provisions of the Constitution which call for public participation. Examples would be in Article 132, for instance, under the functions of a president, Article 132, Subarticle 2, under the functions of a president, the Constitution says, the president shall nominate and with approval of a National Assembly appoint or may dismiss A, cabinet secretaries, B, Attorney General, C, the Secretary to the Cabinet in accordance with Article 154, and the Principal Secretaries in accordance with Article 155. It is in that instant that then public participation is called for. So that then when the Constitution talks of approve, it means give an opportunity to the parliamentarians to also interrogate the person that is to be approved for whatever position we have. In this case, it is a submission that the Constitution says vote, meaning elect this person. And the test to be derived from that is first past the poll. In other words, at the point of voting, do the parliamentarians vote to support or a majority of them support the nomination? That is the simple question that will be presented before you for determination. Permit me then to move on to speak to the place of public interest in relation to this process. Now, it would be expected that pursuant to the provisions of Article 146(2), that when a vacancy occurs in the office of the president, the deputy president shall assume office as president for the remainder of the term of the president. Number 2, that is Article 2B, that if the office of deputy president is vacant or the deputy president is unable to assume the office of president, the Speaker of the National Assembly shall act as a president, and an election to the office of the president shall be held within 60 days after the vacancy arose in the office of the president. What is the public interest question? The public interest question is, it is expected, it is a legitimate expectation by the people of Kenya that they'll have a president. In the absence of a president, they will have a deputy president. In the absence of a deputy president, that will have a situation where the speaker would be able to steer the country into an election. The public interest question that we want to ask or present to the court, would it be in the interest of, now that it is clear that there is no occupant of the office of the deputy president, would it be in the interest of the public to expect or to push the country to a potential election under this article because we want to issue orders that would stay the filling of that office? In our understanding, my lords and my lady, that would be pushing the Constitution a little too far. it should not be lost on us that this same petitioner, the move of this very petition, during the discussions around the motion itself, we had terms like kufa dereva, kufa makanga. What stops him from filing yet another impeachment motion against His Excellency the President tomorrow? It shall be processed. If it is processed, we'll have walked straight into a constitutional crisis. Now, that militates against public interest. And we're saying crisis because we live in this country, and we know that as a matter of fact, we do not have a duly constituted electoral commission. Even if it was the case that we have a deputy president as of today, then pursuant to the provisions of, again, Article 134, which speaks to temporary incumbency, such person would not be able to appoint the electoral commission. What then does that mean? It means potentially that the first person to get to Uhuru Park and get sworn will be the president. My lords and my lady, is that a position would want to allow the country to get into? I need to add by saying this, that these constitutional principles are exercised within a particular context. It is a political context. Political context by its own nature, and I had my learned friends speak to the fact that we live in a constitutional democracy, is a competition. In that competition, there will be those who will be for one party and those who will be for the other party. Naturally, it follows that when one party loses office, there will be some measure of discomfort. What then does the court do? It is in those occasions that the court rises to steer the country through that process so that then the competing interests are balanced in a way that ensures the stability of the country. And because they're deep, it's very interesting and very, something to be very proud about to be Kenyans today, that we are talking about such sensitive issues in this sort of a civil environment. My lords and my lady, in other places, when we talk about this sort of transition, these are constitutional transitions, they end up subjecting the populace to more difficult positions. Now, because we have this opportunity, what then would the court be considering in whether to grant the orders that have been sought or not? My lords and my lady, the constitutionalism speaks to something we call utilitarianism. Utilitarianism dictates that the court helps maintain what I would call constitutional homeostasis. That means that we then ensure that whatever decision we take is such as to ensure there is stability within the country and that the country is given an opportunity to move on. My lords and my ladies, these are jurisprudential discussions that have found favor with those who have been there before us. We've been told in our learning of jurisprudence about Jeremy Bentham, about Arthur Stuart Mill. They were great proponents of utilitarianism as a concept of constitutionalism. May I also invite you to the works and findings of Roscoe Pound, who postulates that the law is supposed to be a tool of social engineering, and that then in its implementation, that social engineering is supposed to help to bring stability within the nation. My lord, my lady, it only follows that for us to achieve that stability, then the orders that were issued and that there are ex parte are orders that are supposed to be set aside, the country allowed to move aside. I am most obliged.
Thank you.
My Lord, the presiding judge, as I settle down and begin to make my submission in opposition to the notice of the motion before you, may I kindly request the court to ask that that light, which is a bit blinding, be either angled further up or turned off completely.
The light has had.
I guess that makes it a smart light. It can understand and react. My Lord, the applications for you for conservatory orders this evening are posed. For the record, I am Paul Nyamodi. I am on record with my learned friend, Mr. for the second respondent. And my Lord, I wish to commence my submission by saying that the task before you this evening is a rather simple task. Listening to my colleagues making their submissions, one would be forgiven if they form the impression that what was for hearing before you was the petition proper. It is not. What is before you for hearing are two applications for conservatory orders. And my Lord, it is my submission that the criteria which you will no doubt consider when you retire to consider your decision in this matter is straightforward. Is there, do the petitions before you disclose inherent merit? Would those petitions be rendered nugatory if the conservatory orders that are sought are not granted? And lastly, and most importantly, is it in the public interest to grant the conservatory orders that are sought? I wish to state that the purpose of a conservatory order, or the ultimate beneficiary of a conservatory order, is the court, and not the party that seeks the conservatory order. I say so because the purpose of a conservatory order, my lords, is to preserve a situation so that the orders of the court upon conclusion of the hearing of the petition are efficacious. That is not achieved by returning anybody to office. That is merely achieved by maintaining a certain status quo for the benefit of the court. So anybody who seeks to persuade you that they can be returned to office by a conservatory order, then perhaps has misunderstood what indeed a conservatory order is. My lords, just to pull the strands together from the submissions that have been made by my learned colleagues for the respondent, and the context in which I urge my lords, my lady, to view those submissions, is that they have spoken to the first ground. They have spoken to the first ground in Peter Munya. They have spoken, or they are responding to the question, is there inherent merit in the petitions that are before you? All the submissions about public participation, all the submissions about the Article 50 rights are all in an attempt to persuade you that there is no inherent merit in those petitions. And I don't wish to go back on those, but I wish to just put two issues before you in respect of the question of inherent merit. My lords, my lady, when you retire to consider your decision in this matter, I'm sure you will need no reminding that the issue of, or a merit review of the impeachment process is beyond the ability of this court. So reject any requests from the petitioners to conduct a merit review of the impeachment. What this court is able to do, and I believe that is the decision of the Supreme Court in Sonko, is to carry out a process review. And so that you are, so I then submit that in determining whether there is inherent merit, this court must then constrain itself to carrying out a process review. My lords, my lady, the second point I wish to make in respect of inherent merit is this. These petitions arise from a concluded impeachment process. In that impeachment process, as you have heard, there were 11 grounds for impeachment. From those 11 grounds, the Senate rejected 6 and confirmed 5. Out of those 5, 3 grounds, and those are grounds 1, ground 5 and ground 6 turned on the conversation or the issue that has come to be known as the shareholder narrative. Now, the first petitioner does not deny that he said those things that he is alleged to have said. It is my submission that there being no denial as to those utterances from the first petitioner, he acknowledges that he said them. There is an admission from the petitioner that he said those things that he said. Now, those 3 grounds of impeachment flowing from facts that the petitioner has admitted, can there be any inherent merit in a petition that seeks to challenge grounds that he has admitted? Ground 1, ground 5, and ground 6 all flow from the shareholder narrative. It is my submission that there can be no inherent merit in those petitions. The finding by the Senate flows from an admission, and that then takes away the ability of the first petitioner to challenge the Senate's findings. My lords, my lady, I wish to move on to the second ground, or the second issue that you would need to consider when you retire to consider your decision on this matter, and that is the issue of whether the petitions will be rendered nugatory if the conservatory orders that are sought are not granted. And I wish to submit on it with the conjoined issue of what is the appropriate remedy in the circumstances of these petitions. My lords, my ladies, in my preparation for my submissions before you this evening, I came across a pitch of a decision. And I wish to persuade you that the applications before you are for dismissal. And I wish to persuade you by reference to the notices of motion that are before you and to decisions of this court that have been rendered in respect of similar matters. My lords, there is a decision that is in pari materia with this one completely, and I say so for these reasons. The decision, and we have filed it as in a supplementary list of authority, is the decision of the High Court of Kenya in Constitutional Petition number 4 of 2024, Purity Mora Kerira versus the Senate and 8 others. It is a decision of the High Court of Kenya in Nyamira. And it is a decision of your sister, Justice Wilfrida Okwany. We have filed it as a supplementary authority, but I have taken the liberty, because it is important to our submission, to make copies available to the bench, which I wish to just walk you through quickly during my submission. My lords, I submit that that decision is in pari materia with this one for the following reasons. It arises from our impeachment process of the Deputy Governor of Kisii County. As I will demonstrate in a moment, the impeachment was preceded by litigation. The impeachment of the first petitioner in this matter was preceded by no less than 29 petitions. My lords, in that matter, a conservatory order was issued in a petition brought by a surrogate litigant. And perhaps I might want to explain what I mean by a surrogate litigant. Our constitution enables constitutional litigation by a person other than the direct beneficiary of the order sought. And for the purposes of my submission, I seek your lordship's permission to refer to that sort of litigation as surrogate litigation. In this matter, a conservatory order is issued in a petition filed by a surrogate litigant. Subsequent to the to the impeachment of the Deputy Governor of Kisii by the County Assembly of Kisii, the matters are then, or the various matters are then directed through the office of the principal judge to Lady Justice Wilfrida Okwany, sitting in Nyamira. And Lady Justice Okwany is then faced with an application such as the one before this court this evening, where a party who has obtained ex parte conservatory orders wishes to persuade the court to confirm those orders. My Lord, I wish to start my reference to this decision in paragraph 63 of that decision. Paragraph 63 is to be found on page 17, and in her usual succinct style, Lady Justice Okwany holds as follows. My attention is drawn to the use of the term "and" in the above cited decision, which connotes that the parameters set for the granting of conservatory orders are to be considered conjunctively and not disjunctively. The decision she's referring to is the decision of Wilson Kibera versus the Judges and Magistrates Vetting Board. It is in paragraph 62, and it sets out the criteria for the grant of a conservatory order. She goes on to conclude in paragraph 63. This means that the failure to satisfy one parameter leads to the collapse of the entire application for the failure to meet the threshold set for granting of conservatory orders, and is used between the threshold issue, between the issue of inherent merit and nugatory. We have submitted sufficiently on the issue of inherent merit. I will not add to it. I will leave it to your lordships and your ladyship to decide. But I wish to state that in the petition before you, the petition would not be rendered nugatory if the conservatory orders sought were not granted. And I wish to commence that submission by reference to the notices of motion themselves. The first notice of motion I wish to refer the members of the court to is the notice of motion in petition 565 of 2024, where the first petitioner, the deputy or the former deputy president of the Republic of Kenya, is the petitioner. My learned colleague, Mr. Gumbo, has gone through the prayers that are spent and those that are live. But I want to focus on prayer 6 and prayer 7. Prayer 6 and prayer 7 of the notice of motion. Prayer 6 reads, pending the hearing and determination of the petition, a conservatory order be issued staying the effect, implementation in any way, including by gazettement and by any person, of the vote resolution made by the Senate of Kenya on the 17th of October 2024, upholding the impeachment charges against the Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua. Prayer 7 says, pending the hearing and determination of the petition, a conservatory order be issued staying the implementation in any way, including by way of transmission to the National Assembly or the President of the or to the President of the Republic of Kenya, the vote/resolution passed by the Senate of Kenya on the 17th of October 2024, upholding the impeachment charges against Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua. My lords, my ladies, I wish to refer you now to the other notice of motion before you. That is the notice of motion in petition number 15 from Kerugoya. And I wish to refer you to prayer D in that notice of motion. Prayer D in that notice of motion reads as follows. Pending the hearing and determination of this petition, this honorable court be pleased to issue a conservatory order staying the implementation of the resolution passed by the Senate and published by Gazette Notice number 13,400 on the 17th of October 2024, removing the Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua, from office by way of impeachment. Those three prayers seek to stay the impeachment. Mr. Gumbo has submitted about the effect of the impeachment. I wish to refer you now to the finding of your sister, Lady Justice Wilfrida Okwany, in respect to those sort of prayers. My lords, paragraph 71 of Justice Okwany's decision reads as follows. In the instant case, I note that the impugned impeachment process has already gone full circle, has been concluded, and a final resolution made by the Senate to impeach the 9th respondent. And again, here the Deputy Governor was the 9th respondent, and the petitioner was the surrogate respondent. 9th respondent, as at the time the instant petition was filed. It is instructive to note that the impeachment proceeded despite spirited attempts by the 9th respondent to stop the process through applications made in similar petitions that are still pending before various courts. That is not too dissimilar to this, and those are the petitions that are before you under the first cohort, petition 522. Paragraph 72. The question which arises is if this court can issue orders whose effect will be to stay the decision by the Senate to impeach the 9th respondent pending the hearing and determination of the petition. My finding is that since the Senate has already made a resolution, the court must exercise restraint and limit its intervention in the impeachment to hearing the merits of the petition. I further find that issuing conservatory orders to stay the Senate's decision will be akin to directing or interfering with other organ/arm of government in exercise of its mandate. My lords, my ladies, in respect of the two prayers or the three prayers that I have highlighted, I urge you strongly to adopt the same finding as Lady Justice Okwany in paragraph 71 and 72. My lords, my ladies, Lady Justice Okwany then goes on substantively to deal with the consideration on the second ground of nugatory. In paragraph 73, she states, the other pertinent question is whether the instant petition will be rendered nugatory or worthless if the orders sought in the first application are not granted. Now, she then begins to reflect on the nugatory consideration. My lord, in paragraph 74, she states, the answer to the above question is to the negative. And she starts straight from the beginning by saying no. I find that the applicant's claim that the petition will be rendered nugatory to be misconceived and unfounded. My finding is informed by three main issues. And she goes on. Firstly, the applicant's petition is still pending for hearing and is therefore possible that the court may, after hearing the petition, arrive at a finding that the impeachment process was flawed. Very much like in this matter. She goes on. In such any eventuality, the court may grant the petitioner and indeed the 9th respondent various remedies, including, and this is important, compensation for wrongful removal or reinstatement. Compensation for wrongful removal. One of my learned colleagues suggested that compensation or 1 month's salary is a remedy. That is a remedy as confirmed by your sister, Lady Justice Okwany. And she also states that reinstatement is possible. She goes on. I find guidance in the decision in Mohammed and 6 others versus the County Assembly of Wajir. This is the decision called the Wajir decision, where the court ordered for the reinstatement of the governor who had gone through the entire impeachment process up to the Senate. The court rendered itself thus, and this finding is important, and I submit that when you retire to consider your decision in this matter, go through the Wajir decision and see the entire raft of relief that 3-judge bench sitting in Meru did. And the relief was as follows. As appropriate consequential relief, an order of mandatory injunction is granted against the 8th respondent, Ahmed Ali Mukhtar. This was the deputy governor who had been sworn in as governor after the impeachment of the governor, compelling him to hand over and restore the office of governor of the county of Wajir to the 7th petitioner, Ambassador Mohammed Abdi Mahmoud. That is the appropriate remedy. And I had stated at the beginning that a conservatory order is given for the benefit of the court, not for any party. And if the court then has that ability, then there is no need, I submit, to then issue a conservatory order. But to explain herself further, I refer you to paragraph 77 of that decision. Lady Justice Okwany states as follows. She states that this court takes the view that an impeachment process can be likened to an election process where, for example, a governor and his deputy are elected by majority votes. Following such an election, The will of the majority voters prevails and is acted upon within the timelines set under law. This is done through the gazettement and swearing in of the deputy governor, and his deputy, within the set timelines, irrespective of the existence of a petition challenging it. In other words, the outcome of an election cannot be stayed through a conservatory order. Suffice it to say that if at the conclusion of the election, petition challenging such an election, the election court finds that the election process was marred with irregularities, then the election will be nullified and the aggrieved party granted suitable reliefs. Importantly, in paragraph 78, in similar fashion, and as I have already stated in this ruling, if upon hearing the merits of the instant petition, this court finds in favor of the petitioner, then the ninth respondent will get appropriate remedies, which may include reinstatement to his position of deputy governor, as was held in the Wajir case. And I urge you to substitute deputy governor with deputy president. There is no difference in the position. He is a deputy to an executive office created under the Constitution. She concludes, I am therefore not persuaded that the instant petition will be rendered nugatory unless the conservatory orders sought are granted to the first applicant. My Lord, this is the same as in this matter. There are effective remedies. There is reinstatement. There is damages. My Lords, reflecting further on the issue, in paragraph 79, the last sentence or the second last sentence beginning on the third line from the bottom, Lady Justice Okwan says the following. I further find that since the office of deputy governor is a public office, it does not belong to a specific individual. It follows that once the office holder is impeached, he has to give room to the next office holder, unless and until such impeachment is overturned or nullified by an order of the court. There is no difference in this matter. The office of deputy president is an office in the public service. It has been submitted that it is a trust. It does not belong to, there is no right post-impeachment that the first petitioner can claim to that office. But profoundly, in paragraph 80, she concludes as follows. I find that in the circumstances of this case, the rights / interests of the people of Kisii, I urge the court to read the people of Kenya, to be represented and served by a duly appointed deputy president. Read deputy governor, read deputy president, following the 9th respondent's impeachment, far outweighs the prejudice, if any, that the applicant herein will suffer if the orders sought in her application are not granted. My lords, my ladies, at this juncture, I wish to refer you to prayers 8 and 9 in the notice of motion in petition E565 and prayer E in the notice of motion in petition E015. Prayer 9 says, pending the hearing and determination of the petition, a conservatory order staying the President of the Republic of Kenya, His Excellency William S. Ruto, from nomination of a person to fill the vacancy in the office of Deputy President. And 8, pending the hearing and determination of the petition, a conservatory order restraining the National Assembly of Kenya from discussing, vetting, voting, and or approving the nomination of the person submitted to the National Assembly made on the 18th of October 2024 by the President of the Republic of Kenya, His Excellency William S. Ruto, to fill the vacancy in the office of Deputy President of the Republic of Kenya. Prayer E in the notice of motion from Kerugoya is the same. In light of the findings of your sister, Lady Justice Okwan, in paragraph 79 and 80 of her decision, I submit that those prayers are untenable. To express myself slightly differently from Lady Justice Okwan, what she acknowledges in paragraph 78 and 79 of that decision is the public interest. The third limb of the considerations that you would need to consider when you retire to consider this decision. It is not in the public interest for somebody who has been impeached to come to court, for the court to maintain a vacancy in that public office pending the hearing and determination of a petition on challenging their impeachment. That is quite apart, my lords, my ladies, from the fact that this court can fashion appropriate remedies. It is not in the public interest. As recognized by your sister, Lady Justice Okwany, the people of Kenya have an overwhelming right to have that office of Deputy President occupied during the pendency of the first petitioner's challenge of his impeachment before you. And that right is acknowledged as being infinitely larger than any prejudice that may be occasioned to the first petitioner if that office is filled. My lords, my ladies, there was a submission that it would be impossible to remove a deputy president if he is sworn in because of an immunity that is enjoyed under the Constitution. I believe that the immunity, and I believe it is Article 143 of the Constitution, is to the president only. And I submit, my lords, my ladies, that it is possible for the orders of this court to be efficacious without reference to the president. Mr. Mudhomi's client is and remains amenable to the orders of this court. And that remains so even if he ascends to the high office of Deputy President of the Republic of Kenya. My lords, my ladies, the conclusion of your sister, Lady Justice Okwany, and I wish to conclude just by referring you to paragraph 82 of her decision, where she says, flowing from the above advisory opinion, and she is quoting the advisory opinion of the Supreme Court in the Speaker of the County Assembly of Embu. And because we are acknowledging matters that we argued, I must acknowledge that I did argue that matter. Quoting that advisory opinion, she says, I find that the moment the Senate made the resolution to impeach the 9th respondent, the office of Deputy Governor immediately became vacant, setting the stage for the filling of the vacancy within the stipulated timelines. My finding is that the public interest in this case supports compliance with the constitutional and statutory timelines set for the filling of the vacancy in the office of Deputy President, Deputy Governor of Kisii County. There is an argument that has been made by the petitioners that the Constitution creates a timeline of 74 days for concluding the process. The Constitution, yes, does provide 74 days, but there is nothing wrong with concluding the process in a faster time than days. Nobody has suggested that that is unconstitutional. Nobody has, other than expressing, surprise as to the speed at which it happened, nobody has said what's wrong with it. Going by the finding of Lady Justice Okwany, I trust that I have persuaded you that the two notices of motion before you this evening are for dismissal. They should be dismissed, and you should then enable the public interest and the people of Kenya to then have a deputy president as entitled by their constitution. I am most obliged. I will take my seat unless my lords, my ladies have anything you wish me to clarify.
Thank you. How many people do you have who are yet to submit?
My Lord, I am checking the least minimum time. And I believe there are two more from our side to answer your question. My Lord, there are two more.
Two more from this side?
Yeah, two more from this side and very short submissions.
Okay.
My Lord, allow me to just make two crisp points.
There's a need for health break.
Yes.
Okay. So we resume in 10 minutes time.
Thank you, my Lord.
You finished the water you're
Unatazama Sound Candy Talk. Toa sauti yako usikike. Naikara, Shangoe, Ilimatuok, Loita, Emrwadikiri. Kutoka Kimilili Bungoma hadi Kiminini Trans. Unatazama Sound Candy Talk. Toa sauti yako usikike.